Good morning all. We're here for the hearing in the matter of CA-010 2018 before Justice Sir Jeremy Cooke, Justice Judith Prakash and His Excellency Justice Shamlan al-Sawalehi. The appellant is represented by Clifford Chance, Lead Counsel, Yun Mukota QC, assisting is Camilla Bingham QC. The respondent is represented by Hamdan al-Shamsi, Lead Counsel is Alistair Thompson, assisting is Andrew Rose.
Yes.
My lords and my lady, good morning. This is my client's, the second defendant, appellant's appeal against paragraph 2 of the order of the Deputy Chief Justice still made on the 18th of April of this year, in which he refused my client's, the second defendant's application to strike out the 2016 proceedings as an abusive process. That application was having been brought on the basis that the claim in deceit, which is the only claim which now remains in this action, the others having been struck out on limitation grounds, that claim in deceit could and should have been brought in the 2009 proceedings. Now, the order, I hope that your lordships and my lady have a core appeal bundle, a small core appeal bundle, as well as the array of bundles from below, I think, too. But in the small appeal bundle, the learned Deputy Chief Judge's order is behind tab 1, and you'll find that on page 2. And it's against paragraph 2 that we are appealing.
Yeah.
The appeal is brought with the permission of the judge, which was granted generally without restriction as to grounds. And for your lordships note, that's in the same bundle at tab 9, the core bundle at tab 9.
Yes.
Now, my lords and my lady, the 2009 proceedings, they were issued on the 7th of October 2009, so they have been going for some 9 years. And indeed, they are still continuing with unresolved issues of interest and costs. They were and have been hard fought on both sides. There have been substantial legal teams, silks, multiple junior counsel, solicitors teams. They reached a trial on liability issues between the 19th and 28th of May of 2013, closing submission somewhat later. There were some 51 trial bundles, including hundreds of pages of expert reports on accounting, banking, Swiss law, Kuwaiti law. Cross-examination of witnesses of fact took 7 days odd. And you get an idea of how heavy duty the litigation was if one realises that the Deputy Chief Justice Chadwick's judgment on liability after trial, which for your note is in bundle 8 behind tab 75, runs to some 170 pages. That was in August 2014. He delivered a subsequent judgment on issues of quantum, October 2015, which runs to some 91 pages. And there were appeals on liability and quantum, and the Court of Appeals judgments, which are at bundle 10, tab 101, and bundle 11, 105, run together to over 150 pages. Now, this was, I mention that because this was full-on commercial litigation. It was, and as well as the very substantial time which the parties devoted to it and the expense they incurred, it took a very substantial amount of judicial time and resources, that litigation. And my client, the second defendant, has spent some 9 years defending it and counting. And at the permission hearing in this case, permission for appeal hearing in this case, we were presented, that was on the 3rd of July this year, we were presented with an estimate of the claimants' costs of the 2009 proceedings at in excess of $19 million. That's in Mr. Bowden's witness statement, Bundle 1, tab 21b, at paragraph 11. Now, it turns out, however, that the 2009 proceedings have just been some kind of warm-up, or a amuse-bouche. The claim for 70 million is a warm-up act, and the claimants now bring a very much larger claim, said to be $1 billion, based on the same facts, and which were part of the subject matter of the 2009 proceedings. And they seek to deploy what they say are issue estoppels from the 2009 proceedings, which they say takes them home, 90% home on liability issues of the 2016 action. Now, I should up front, and at this point, deal immediately with one of the grounds of appeal, ground 12, because it relates to the protracted length and expense of the 2009 proceedings. The grounds of appeal, my order in the core bundle behind tab 3, and this is ground 12 under and I refer to this now because it relates, I've mentioned the length and expense of the 2009 proceedings. And I mention it for this reason, that the protracted length, the huge expense of the 2009 proceedings should have been treated by the learned judge as a factor showing why vexing my client, the same defendant, in two sets of proceedings over the same subject matter was unfair harassment and was abusive. And instead, the learned judge's analysis of that factor was entirely incorrect. And the vice thereby created was that he impermissibly left it out of account. And he impermissibly left out of account the protracted length and expense of the 2009 proceedings as a factor in why the current proceedings are now abusive. And he left it out of account because he said that it was largely self-imposed by my client, the second defendant. Now, as to what the judge said about it in his judgment, which is behind tab 1 of the small core bundle, he addressed this in paragraph 36, where he says, at the beginning of page 16, there is no doubt that the 2009 proceedings were protracted and needed yet to be completed and expensive. But much of that was self-imposed by the bank, that's my client, second defendant, who challenged every aspect of the claimant's case: jurisdiction, disclosure, liability, quantum, costs, followed by appeals of both liability and quantum. Now, he's effectively saying that the bank, second defendant, had itself to blame for much of that. The implication seems to be that it conducted itself in an unmeritorious or perhaps even improper way. Now, that is something of a hostile comment towards my clients. And when one looks at the 2009 proceedings, it's a comment that is completely unwarranted. And I noted from the transcript of the permission hearing that Mr. Fraser from the claimants belatedly, expressly conceded that the claimants are not saying that any of the second defendant's challenges in the 2009 proceedings were improper. So the claimant is now not saying anything we did in the 2009 proceedings was improper. Although the judge's attitude was, I have to say, certainly to some degree, fueled by the claimants along the way, because as recently as the claimant's skeleton resisting permission, which is behind tab 5 of the core bundle, we see the claimants saying much of a piece to a number of the comments made below in paragraph 10, page 66. In truth, the appeal is yet another example of the determination of the bank noted in the judgment to challenge each and every adverse finding made against it by the court, no matter the merits or lack of them involved, which has led to the unduly prolonged nature of the two sets of proceedings against it. This is a particularly egregious example. Now, my lords and ladies, removing the length and expense of the 2009 proceedings as a factor by blaming my client for that simply cannot be justified on the facts. And I think a lot of this stems from the judge, in his mind, wrongly eliding the positions of the first and second defendants. They had the first defendant had separate counsel representation throughout, and it was criticised for its conduct at a number of points in the 2009 proceedings, but the second defendant was not. The judge, in his judgment, referred to a number of matters. First, he referred to jurisdiction. Well, on jurisdiction, my client's jurisdiction challenge succeeded at first instance. The claimants appealed, and they succeeded. The appeal court's judgment, which we should perhaps go to just briefly, it's in Bundle 3, that's tab 46. This is the appeals court's judgment on jurisdiction in relation to my clients in the 2009 proceedings. One sees from that judgment that the claimants took multiple points on jurisdiction, which were all but one rejected by the Court of Appeal.
I'm sorry, could you repeat the reference, please?
Yes, of course, my lady. It's in Bundle 3, tab 46, which is the first tab. The document I'm going to is the Court of Appeal's judgment on jurisdiction on the 5th of January 2012 in the 2009 proceedings. The point I sought to extract from that was that it was the claimants, not my client, the claimants took multiple points on that appeal, which were all but one rejected by the Court of Appeal. And indeed, one of their arguments, for example, we see on bundle page 1076, an argument based on Article 5A1 of Law 16, was rejected in paragraph 81 as being entirely misconceived. That was a claimant's argument. It was an argument to the effect parties couldn't contract out of certain provisions of the law. Other arguments were rejected, many of them. And noticeably, the Court of Appeal at paragraph 108 on page 1080 of the bond, paragraph 108, found that there was a valid and effective jurisdiction agreement between the claimants and my client, which covered the claimants' claims advanced in the 2009 proceedings. They found at paragraph 118, which is over the page of bundle page 102, that Switzerland was certainly the natural forum for the case, but the only reason why jurisdiction was maintained in the DILC, one sees it 119, was because there was acceptance that there were exceptional reasons not to hold the claimants to their jurisdiction bargain, because and allowed them to resolve from that bargain because the first defendant was being sued in the DIFC. So the criticisms of our conduct in relation to jurisdiction cannot be justified. Points were reasonably and properly taken, and almost all of them were successful. On disclosure, there was a measure of success on both sides in that action, as you might expect with major commercial litigation. But we remain dissatisfied on the disclosure we got on the claimant's assets, but that was a feature of the case. On liability, which the judge also mentioned, you may recall that the judge, one could put bundle 3 away for the moment, you may recall that the judge referred in paragraph 30 of his judgment back in the core bundle behind tab 1 of paragraph 30, he referred to a gloomy advice, which was an advice received by the claimant's funders early in 2013 from Mr. Jeremy Cousins QC, who advised that...
Wait, I'm not anxious to stop you mid-flow, but speaking for myself for leisure, the points that really interest me are the questions simply of could the point and should the point reasonably have been taken.
My Lord,
whether in February 2012, in August 2012, or thereafter.
My Lord,
and secondly, so far as quantum is concerned, whether in any event the quantum claim was one that could have been put on the basis of the existing causes of action. And I'm mindful that deceit can give rise to a different measure of damages from the ordinary measure in tort, for negligence, for example. But the key to this, and I know you have multiple grounds of appeal, but the bottom line is very simply, ought the point to have been taken, and this is abuse that could be taken at a later stage. And it seems to me that in reality, that point hangs on the very elements that I've just described. If you want to persuade me that those aren't the key elements and there are other matters that are of equal importance, then by all means do so. But I simply make that point for your guidance as to where I would like you to go.
My Lord, I'm very, very grateful for that indication. And to use a colloquialism, I think Your Lordship and I are on the same page, as it were, because those are the points that I'm coming to, having just dealt with this point about the length and expense of 2009. And apologies if I laboured that point. I wanted to get it out of the way to indicate, because because it goes to the oppressive nature of the second set of proceedings. But I quite agree with Your Lordship that it's important that we get very quickly to the points that Your Lordship has indicated, and I'm coming to those directly afterwards. If Your Lordship would indulge me one moment longer just to conclude on the point I was making, so that Your Lordship's have it, and then I'll...
You have my indulgence.
And Your Lordship, the only other thing I was going to do before I reach those 2 points which Your Lordship obviously regards as key to the case, and are obviously extremely important, was to just remind ourselves of the legal test that was faced on this appeal. But just before I do that, to conclude on the point I was making, my Lord, on the liability question, we had a significant, even the defendants, claimants funders had pessimistic advice. We had a significant measure of success on liability in knocking out a lot of the claims in the 2009 proceedings. And so far as quantum in the 2009 proceedings is concerned, which was the Deputy Chief Justice also referred to critically, we were sued for 75 million. They got judgment for some 35 million, so there was quite a degree of success there. And we also were able to keep out further claims for tower losses. And the final point the judge referred to was the question of costs. No order of indemnity cost was ever made against my clients in the first proceedings. It was made against the first defendants on occasion, but not against my clients. It was sought on one occasion, but was specifically rejected by Deputy Chief Justice Treadwell. So no viable criticism there. My Lord, the legal test, and for that I need to refer to just 2 cases. First of all, Alia itself, which is in the first authorities bundle behind tab 13. And if I could invite you to bundle page 203, this is the English Court of Appeal, and just perhaps as easy if I just read you the Lordship's and relating the relevant passage into paragraph 16 in the conclusions. In considering the approach that was taken by this court to the decision of the judge, it was rightly accepted by Aspinall that the decision to be made is not the exercise of the discretion of the FSP were wrong in contending otherwise. It was a decision involving the assessment of a large number of factors, to which there can in such cases only be one correct answer to whether there is or is not an abusive process. Nonetheless, an appellate court will be reluctant to interfere in the decision of the judge, where the decision rests upon balancing such a number of factors. And then assigns authority, and then dropping to the letter D, the types of cases where the judge has to balance factors are very varied, and the judgment is important as to the test to be applied when expressed in different terms, and whether it's sufficient for the purposes of this appeal. The statement of an appellate court will be reluctant to interfere with the decision of the judge in the judgment he reaches on the abusive process by the balance of the factors. It will generally only interfere if the judge has taken into account the material factors, omitted to take into account the material factors, erred in principle, or come to a conclusion that was impermissible and not open to it. In this case, I consider the judge, despite the weight that must be according to his views, given his great experience of this type of litigation and the conscious conspicuous success with which he managed the TTC, which is a decision which was impermissible by taking into account factors he should not have done, and omitting factors which he should have taken into account. So only one right answer. It's an evaluative exercise, so the court is reluctant to interfere, and generally will only do so if the judge takes account of factors he should not have done. And just in relation to that, that must of course include where the judge takes into account, where the judge analyses a factor wrongly, and if the judge does that, then obviously, and then takes that into account, that must be taking into account a factor he should not have done. Otherwise, if the judge omits to take into account material facts or factors or errors in principle or reaches an impermissible conclusion. And just a rider to that from Stewart and Goldberg in the bundle behind the next tab in the English Court of Appeal, behind tab 14, Sir Anthony Clark, Master of the Rolls, at bundle 232, paragraph 81, where he has, in the passage at the foot of bundle page 51 of page 232, he cites the Aldi passage that was looked at, and then he says at plan C in 232, I agree with that analysis, subject only to this, the judge is completely clearly wrong. It would be the duty of the appeal court to interfere. I feel sure referring to the possibility the judge might come to a conclusion that was impermissible and not open to him, where Justice Thomas intended to include the case where the judge is plainly wrong. In the event that further reviews should be included. So plainly wrong is included, and one also needs to look just across the page of 233 at paragraphs 85. You see just below that A that the judge in the third line agrees with Lord Justice Lloyd that the judge is wrong in two respects about what she took account of. And he says, therefore, in 86, in these circumstances, applying Aldi, as I see it, it is, as I see it, for us to consider afresh whether this action is an abuse of process. So, if the judge did take into account irrelevant factors he should not have done, and so forth, this court can look at the matter afresh. And we say, of course, that the judge has done so in this case. And just a comment on that, although some passages in those cases may read like quite a high bar for an appellant, but of course, in the two appeals, in Aldi and in Goldberg, they were both allowed, of course, and in a third of the 5 English Court of Appeal cases here, Clutterbug, the appeal was allowed in part. So it would seem, at least on those cases, that the appellants have had something like a 50% chance result of success. Now, as to the order of taking the remaining grounds...
do you or do you not say that the judge failed to apply the Aldi guidelines here?
Yeah, we do criticise the way he dealt with the Aldi guidelines.
I'm sure your experience in advocates, and certainly mine as a first instance judge, is that courts of appeal never have any difficulty in finding factors that have wrongly been taken into account, or vice versa, if they want to interfere with the decision.
Yeah.
And rarely is that truly a justification. It's more a ex post facto justification.
Well,
But what I'm asking you is, when we come to look at the Aldi guidelines, is it a question of failing to apply the guidelines, or is it simply a question of weight being wrongly attached, as you would say, to one factor rather than another?
No, it's a failure to apply the guidelines, and so it's an error of principle, which I will be saying when we come to that. And we also do make the point, particularly in relation to other grounds, that there were matters that were wrongly analysed by the judge and then taken into account, and other matters which were impermissibly left out of account. One of those being the length and expense of the 2009 proceedings, as I mentioned in it, which was left out of account on an entirely erroneous basis. As to the proposed grounds of appeal, I think it would be, and this falls well given your Lordship's indication earlier, I will deal next with grounds 5 and 6, which, and I'll explain why if it isn't obvious. Your Lordships will recall that the judge held in paragraph 31 of his judgment that the crucial question which arose was what order would have been made if the claimants had applied for permission to amend to plead the deceit claim in the 2009 proceedings. You described that as the crucial question in paragraph 31. And in terms of timing, the judge placed that hypothetical amendment application, or CMC, in April 2013. That is to say, right on the doorstep of the trial that was due to commence on the 19th of May. Now, one of our key complaints is that that's far too late. And because, of course, it loads the dice against the second defendant, because it potentially narrows the court's options on the hypothetical CMC as to how it can case manage the new claim in the 2009 proceedings. And if the hypothetical CMC should have taken place later, taken place at the latest by the middle of 2012, which is what we say, then the options are vastly greater. In fact, it becomes extremely easy to case manage the claim within the context of the 2009 proceedings, because you're the best part of the year before trial. Now, as to when the hypothetical CMC should happen, perhaps I should just show you Lordship's treaty in the English Court of Appeal, which is in the authoritative bundle 1, it's 24, which is one of the 5 English Court of Appeal decisions in this relating to Aldi, where Lady Justice Arden, as she then was, said this at bundle page 478. I just draw attention to the fact, just to put it in context, that one sees from paragraph 52 on page 478 that this is the case when the English Court of Appeal held that on an abuse question, the judge below in that case had been entitled to assess the seriousness of the ALDI breach, the breach of the ALDI guidelines, by seeking to determine what would have happened if the necessary application had been made. And she also says in paragraph 50 on that page, just about 3/4 of the way into the paragraph 50, she says the application should have been brought as soon as reasonably possible after a treaty should have appreciated threatening its potential liability. So you should make your application as soon as reasonably possible after the claimant should have appreciated the defendant's potential liability. Now, the judge, in my submission, in our case, fell into error about the date for the hypothetical CMC, or amendment application, because he was, as your Lordship has obviously noted, he was not persuaded that the claimants could properly plead the deceit claim until then. Indeed, he was even a bit sceptical about that date in his judgment. Now, there are 2 key reasons why the judge took the view that the deceit claim couldn't be pleaded till that point. And they are really our grounds 5 and 6, which is why I'm going to go to those next. Because we say that if we are right about grounds 5 and 6, that means that the judge considered the hypothetical CMC, his consideration of the hypothetical CMC was fundamentally wrong, because he put it at the wrong time. And that entirely undermines his conclusion of what would have happened. And I suggest that if you are going to, as the judge did, if you are going to elevate the hypothetical CMC's outcome to be the crucial question, it's particularly important that you get the timing and circumstances of your hypothetical CMC right, which, in my submission, he did not. So, round 5, with that introduction, my lords, and you will have the grounds of appeal behind tab 3 of the core bundle. The judge below his judgment, if I could go back to there, at paragraph 27, page 13 of the core bundle, in paragraphs 25 through 27, he reviews some of the materials available to the claimants in relation to the deceit claim, some, and then at paragraph 27, he says this in the first sentence. First claimant's own evidence is to the effect he was unaware until shortly before trial that the US dollars 10 million constituted a margin call. On the material available and the judge's finding of credibility, I think that's referred to Chief Justice Chadwick in the earlier proceedings,
yeah.
I see no reason to reject that proposition. Now, so he accepts the first claimant's evidence to the effect that he was unaware till shortly before trial that the 10 million constituted a margin call. And now if we look at what the new deceit claim is, and we find the particulars in the 2016 the new proceedings in bundle 1 behind tab 5, if we look to see what the new the claim is, you'll find the crux of it on page 36, bundle page 36 of the new particulars of claim, where you see at paragraph 65 and
Sorry,
60.
I am not following your reference.
I do apologise, the fault's entirely mine. Bundle 1 is the general bundles, the series of bundles that come with the core bundle. And I do apologise, Ryan. It's
Perhaps you can slow down after you make a reference.
I'll
We'll stop for a little while so that we can take out these bundles,
I'll take that on
which we are
board.
not as familiar with as you are.
Of course, I'll put that entirely on board, lady, and I do apologise. I was going to go to bundle 1,
Yes.
and if your ladyship has that, I was going to go to tab 5, which is where one should find the particulars of claim in the new action, the 2016 proceedings.
Yeah.
And I was going to look at the deceit claim that is now brought, what it is. And one gets that from paragraphs, page 36, paragraphs 65 and 66. One sees the pleading of the deceit claim, perhaps I'll just read it, 65. By around mid-August 2007, there was already a collateral shortfall of Mrs. Alhammad's account with Bank Safra itself because of the loss of buying the
Well,
notes.
this is taken straight out of the judgment, isn't it? Isn't it? Which
Yeah.
makes no difference.
Yeah. It's taken out of the judgment, and one sees, if one looks at 65, 66, and 68 is the pleading of why it was dishonest, why it was untrue, is the pleading of dishonesty. And that's all the pleading of dishonesty is, at 68. One sees the gist of the case is that Mr. Alia of the first defendant, he's an employee of the first defendant, not my client's employee, lied to Mr. Khorafi, the first claimant, about the purpose of making the $10 million payment to the second defendant, my client, saying it's to make you look good in front of the bank, when in fact there was already a collateral shortfall on the notes which the claimants didn't know about. And it's said to be untrue in 68. It's said to be untrue because the reason for the request is said to be the undisclosed collateral shortfall, and the bank didn't want to reveal that by actually calling for extra collateral. Didn't want to alert the claimant to the fact there was a shortfall, which might have indicated other problems of the investment. So that's the gist of the case. And in my submission, the judge was, and as your Lordship has observed, it comes from Chief Justice Chadwick's judgment on liability. The judge below here was, in my submission, quite wrong, uncritically, to accept the first claimant's evidence in paragraph 27 of his judgment, because that was a thoroughly unreliable piece of evidence, and demonstrably so, on materials which I showed to the judge below. In fact, the claimants and their legal team had the information about the margin call long before trial, not least because it was pleaded by the first defendant under a statement of truth in December 2010. It was pleaded by the second defendant later under a statement of truth in February 2012. The delay, of course, was caused by the jurisdiction challenge in the second defendant's case. It was the subject of disclosure by the defendants in August 2012.
In truth, that didn't add a lot to the defence, did it? The internal memorandum from Mr. Walia didn't say a great deal more than could have been garnered from the earlier defences saying what the case was.
It gave documentary confirmation. So if you're humming and hawing about do I plead fraud or not, it gives you internal bank documentary confirmation that we used this as collateral to meet the collateral deficit, and confirmation of why the money was sought and the money was applied. So it gives you that documentary confirmation from the defendant's own documents. So if you are, because I say that because I note from the Friends Listed Authorities, there are authorities about emphasising rightly that there are professional rules about pleading fraud. You need to have reasonably credible material showing a prima facie case of fraud before you can plead it or should plead it professionally. And I accept all that, and those are important rules, and I'm not in any way seeking to detract from that. But in this case, you've got Mr. Walia's statement of truth on what his case is from December 2010, saying under a statement of truth, this is what I'm going to say. And it's an argument, and it was for extra collateral, and I explained it to Mr. Al-Khorafi. We'll look at that defence. You then get the second defendant adopting that case under a statement of truth, and then you get disclosure of it in August 2012. Now, and you've got this huge piece of commercial litigation going on, and at that point, latest, middle of 2012, at that point, under ALDI, you've got to say, I need to plead this, or at a minimum, I need to raise this with the court under the ALDI guidelines and say, what should I do about this claim? I've got this on the claim.
Well, I'd understood there were particulars given of when he first understood in any event, which have been resolved from.
Well, coming to that, which is one of the reasons why the learned judge below should not uncritically have accepted that piece of evidence. It's one of those reasons. There are others as well, which I'll come to, but the judge has there's no analysis by the judge of why he's uncritically accepting it, other than the fact that Mr. Al-Khorafi was found to be a generally honest witness below. But his evidence was criticised, and I'll come to that, by Deputy Chief Justice Chadwick. It wasn't a clean bill of health Mr. Al-Khorafi got below on the quality of his evidence. And just to make good those points, if I can I, and I'll be as brief as I can, I don't want to labour these points, but if we can look first at the claimant's statement that the judge is accepting in his judgment, that's in bundle 1, the bundle we had out a moment ago, from below. So bundle 1 from below and tab 19 is a statement made for the purpose of the strikeout application. Just apropos of our exchange a moment ago, because the fact that the disclosure doesn't actually add much to what the defence is saying is of course helpful to us, because of course it means that the claimant should have appreciated the case rather earlier, but it does go to perhaps to the forensic legitimacy point of at what point do you have to say, right, I've got this claim, it's now or never, I've got to make it, or I've at least got to raise it with the court, none of which happened, of course. Now, as to the evidence, and I hope your ladyship has.
Yes, thank you.
I'm so much obliged. Behind tab 19, we have Mr. Al-Khorafi's witness statement for the purposes of a strikeout application. And I was going to show you at the top of bundle page 165 the piece of evidence that the judge accepted uncritically in his judgment, which is paragraph 14, where Mr. Al-Khorafi says this: the claims brought in the new proceedings based on the fraud of the defendant at the time I made a $10 million payment in August 2007. I did not know until very shortly before trial in 2013 that the defendants and Mr. Walia, the managing director of the first defendant, so he specifically is saying I didn't know Mr. Walia was doing this either, were claiming that the $10 million which Mr. Walia asked me to deposit in August 2007 was in order to meet a margin call, rather than being, as he told me at the time, a goodwill payment to make me look good with the second defendant. Now, if we look at what material was available before that time to the claimant and his legal team, and their legal team, and they were legally advised throughout the 2009 action by leading and junior counsel and solicitors, although not the current team. So far as the pleadings in the 2009 action are concerned, I can go to it if your lordship wishes, but the way this went was the re-amended particulars of the claim made a complaint that account statements in September 2007 showed losses, but those were not drawn to the attention of the claimants, the first or second claimants. And the first defendant in its defence, in December 2010 said the following, and that, your ladyship and my lords, will find behind in bundle 2 from below, put bundle 1 away, in bundle 2 from below, behind 1044. And I was going to take you to page 1007 of this pleading. First offence pleading in the 2009 action. And at paragraph 94, footer of page 1007, they say this. The following statements were produced and sent by the second defendant. The position on the accounts of the first and second defendant claimants was brought to the attention of Mr. Taha on a telephone call on the 15th of August 2007, Mr. Mayor. He's another first defendant employee. Due to the claimant's leveraging strategy of 15 August 2007, a collateral shortfall existed on the investments. On value date 31 August, some of 10 million was received on the first claimant's account of the second defendant to resolve the issue of shortfalls on the account. The first and second claimants, as well as Mr. Taha, that's the first claimant's accountant, were aware of the position of the accounts by the monthly disclosure statements generated by the second defendant and sent to the claimants on a monthly basis. So, and I draw attention to the fact, so they're saying the collateral shortfall existed in August 2007. That was explained to Mr. Taha, the claimant's accountant, in a telephone conversation on the 15th of August. And the 10 million was received on the first claimant's account to resolve the issue of the shortfall. And this document is signed at 1043, page 1043, with a statement of truth by Mr. Alia himself. So this is what Mr. Alia, the very person who's accused of fraudulent misrepresentation, was going to say. And he's saying it under a statement of truth. He's confirming it under a statement of truth. Now, of course, in the DIFC, as in England, a statement of truth is a serious thing. It's a statement that the party putting forward the document believes the facts stated in it to be true under potential contempt sanctions and so forth, if that person makes a statement without an honest belief in its truth. Now, in the DIFC rules, in the RDC, it's Rule 22.7, there's equivalent in the CPR, of course, and the contempt sanctions, potential contempt sanctions, are RDC 29.137, and there's an equivalent, of course, in the CPR. Now, of course, Mr. Khorafi has always known what he says he was told by Mr. Alia in August 2007, and when he compares the claimant's new case, when he compares that case, his case, if true, to what Mr. Alia is saying in this document, he has to say, hang on, I was lied to about the 10 million. That case, the substance of that case, is subsequently adopted by my clients, the second defendants, in their defence. There's a delay in their defence, as I mentioned, because of the jurisdiction dispute. But they file a defence, and put two away, take up, if I can invite you, please, bundle 4 from below. And on this occasion, I'm going to go to tab 59, bundle 4. This is my client's defence in the earlier proceedings, and it was, the original version was served in February 2012. One sees that from the end at page 1794, and it's also confirmed by a statement of truth on behalf of the second defendant, Mr. Vogel, Managing Director and General Counsel, and it adopts effectively the same case. If you look at bundle page 1758, one sees at paragraph 65, little a, say that it's admitted that on 31st August, the first claimant deposited 10 million. The first sentence is denied. The sum of 10 million, B, the sum of 10 million was transferred by the first claimant to his account of the second defendant in order to cover the margin call shortfall on the account. That's the second defendant's case under a statement of truth. So the claimant...
Well, it doesn't deal specifically with the conversation.
It doesn't deal with the Taha conversation. It doesn't deal specifically with what was said to Mr. Alia, but it deals specifically with the purpose of the payment being requested and received and the use of the payment. And that's said to be the dishonesty, is that it was requested and received for a dishonest purpose, a deceitful purpose.
Yeah.
And so it deals with that. And Mr. Khorafi knows what he thinks he was told by Mr. Alia. He knows that. He's always known that. He was a party to the conversation.
And what's the point of reply to either of these documents that grappled with either of those paragraphs?
I'm afraid I didn't get the first part of your question, sorry.
Was there a point of reply by the claimant to either of these
I'm
defences
not aware of that.
which grapple with these particular paragraphs?
Nothing material from recollection. Well, I'll ask Ms. Bingham to check that. But nothing material that I recall. But if there's any material, we'll bring it to your attention. There are a couple of other paragraphs that are also potentially relevant. On 1765, at paragraph 85, my client says this. Portfolio statements were produced and sent by the second defendant on a monthly basis. Due to the claimant's leveraging strategy, a collateral shortfall existed in the investments. On 31st August, the sum of 10 million was received in the first claimant's account with the second defendant to resolve the issue of margin shortfalls on the account. So again, if he thinks he was told the 10 million was to make it look good, he's been told that that purpose in this document, that purpose was untrue.
The portfolio statements, one takes it, would have revealed the state of the account,
Yes.
the shortfall, the fact that a margin call had been made and margin had been paid. Is that right? And if so, I think perhaps you need to show us that.
Well, I'm not sure they're in the bundles. I don't think they're in the bundles. And there's no reply in the bundles either. I think, perhaps I can I revert to your Lordship on that point, because your Lordship's quite right that if we can pinpoint the point where Mr. Khorafi gets disclosure of those things, even if he says I didn't receive them at the time, if we can pinpoint the point where he gets disclosure of the account statements, then obviously potentially material.
Well, of course, you might say you didn't read them.
But I'm coming to the didn't read the point in a moment, because in the end, that goes nowhere, because if the claimant and his legal team together have the relevant information, it can still be in use to bring them, because going right back to Henderson and Henderson, the court said in that case, that whether it's deliberate, whether it's inadvertent, whether it's negligent, whatever, if you want to blame your lawyers, do that somewhere else. If you want to blame your lawyers for not bringing something to your attention, do that somewhere else. And it can be an abuse if if the omission to plead is through inadvertence or negligence or whatever. So just before I moved on from that document, there was one other passage potentially relevant. I just wanted to check that you much had that, but it's page 1766 and paragraph 19 at the foot of the page. And picking it up about 5 lines in, the investment in the product was funded by the increase in the first claimant's credit facility with the second defendant of 30 million, and the 10 million which was transferred by the first claimant to his account for the second defendant on 31st August to cover a margin shortfall on the account. So it's emphatic about what the second defendant is saying the purpose of that 10 million was. And when...
So that was... The $10 million was to cover the shortfall of the collateral prior to the new loan or after the new loan?
There's a new loan in there, my lady. In fact, what Mr. Al-Khorafi's case is, taken from his witness statement at trial, which was ultimately accepted by the judge, was that he was being loaned another 30 million at that time. And some of that money had obviously, but not all, had been used to make further investments. Some in what the judge called the witch's hat, but not all of it. So there was some remaining. And he says that Mr. Walia called him up to say, look, if you haven't used all of that 30 million, will you invest another 10 million with the second defendant to make you look good? Because it will help you in the future. So there was, a loan was mixed up in that, but it doesn't
So the loan came first, and he had 30 million in his hand.
Yes,
And
he would have been lent the money.
This shortfall was on the total facility, including that 30 million.
I think the point was that the 30 million at that point wasn't available for use as collateral because there was a pledge agreement, and in order for him, yes, it was. Sorry, I've been reminded by this thing, and I'm grateful. It was the second claimant's shortfall. So,
So it was somebody else, his mother or his wife.
His mother.
His mother.
His mother.
So his mother was short, and they asked him to put money in to cover that, not her.
I think the dealings with the bank were principally carried out by the first claimant, even though the mother was, it seems, had a lot
Well,
of
technically he wasn't obliged to.
No. Yes, I think that was the point. And yes, I mean, there's some evidence in the documents we're just about to come to, the disclosure documents, about how the mother was sent to be in the south. The bank understood the mother to be in the south of France.
Yes, but I mean, the point is that he didn't have to put the money in.
Yes,
he had a separate loan of 30 million.
Yes, he didn't have to.
And he then put it in, thinking he was putting some money with the bank, he says, to make himself look good.
Yes.
And in fact, they applied it to a shortfall in his mother's margin account.
Yes, and that's right. And I mentioned what his account of events was. Mr. Walia's account of events was that he didn't have a telephone call. This is the trial account, and we can come to that as necessary. He didn't have a telephone call. He had a meeting with Mr. Al-Khorafi in London, and he explained the collateral shortfall, and Mr. Al-Khorafi agreed. That was Mr. Walia's evidence. And that was rejected by the judge at trial, who accepted Mr. Al-Khorafi's account of that of those events.
Actually, I really don't understand this paragraph at all.
No, I don't understand this paragraph 90 at all in that context.
There was a product which he bought, and his product was funded by a loan, and 10 million, which was covering his mother's account.
Yes,
I see.
Product. Yes, it may be inelegantly expressed. What I suggest is first of all, what I suggest is very clear from the second part of the sentence, starting and 4 lines up. The US dollar 10 million, which was transferred by the first claimant to his account with the second defendant on volume day.
But that's wrong, isn't it?
To cover a margin.
Because it's not a margin shortfall on his account.
Is that because you placed it different? I'll ask, can I come back with the details? I don't want to get it wrong twice. But it may be that his account, it was in an account of his that was then pledged as collateral.
Yes, they were cost collateral.
Yes, cost collateral.
So what's happening is that he takes out a loan. On his case, that's all to be used for his investment.
Yes.
In practice, 10 million of it is being used by way of cost collateralisation, as well as standing to the benefit of his account.
Yes.
That's how it works, isn't it?
I think that is, the Lordship is absolutely right. I think that's right.
And the key question the judge had to decide, which he decided against your client, was what in fact had been said either in a meeting or in a telephone conversation about the purpose of the 40 or the 10 part of 40.
Yes, the 10 part of the 40, which, as your Lordship says, he decided against. The judge of trial decided against my clients.
Yes.
I wasn't going to take your Lordship, my lady, to any further passages in our defence. If I can further illuminate or have anything to add about paragraph 80, or perhaps I can come back to that after a break. But I was going to, for completeness, obviously show the court the disclosure made in August 2012.
I'm more interested in further and better particulars of knowledge.
In that case, I'll just give the references.
You do need to take us to the memorandum as well. So take it in whatever order you wish.
I think it's just chronologically.
Thank you.
That comes next.
Forgive my interference.
No, I think perhaps if I could go there, in bundle one below, so not the core bundle, bundle one below.
Yeah.
When I put 4 away, they're behind tab. First of all, tab 29.
What are you going to do?
Bundle, the first bundle from below. Tab 29.
Yeah.
And now, mine is in really quite a small script, so I hope but it's really just the first paragraph on these for this. And this is from Mr. Nair of the first defendant, 14th of August 2007, writing to the gentleman in the second defendant in Switzerland. Subject, margin call. This is the Al-Hamad margin call. I've set up a conference call between, perhaps I'd ask to very large version so I can read it properly. I've set up a conference call between the financial advisor and the client's son as the first claimant for tomorrow afternoon. We review the portfolio and the current market conditions and also discuss the margin call. Ms. Amrah continues to be on vacation in certain funds, and I'd like to request the following. And this is, he goes on to one. Is there shortfall after considering the cost flows? Certain details about the shortfall. But the important point here.
So this is an internal.
This is internal. It's between the first second defendant sent to the second defendant, 14th of August, and so this is what the second defendant's been told is that there's going to be a call set up to discuss the margin.
Yeah.
And they're behind tab 31 of the same bundle, you should find a disclosed document of the 2nd of September 2007 from Mr. Nair of the first defendant to a gentleman of the second defendant, copied to Mr. Alia, headed subject Al-Hamad Al-Khorafi, dear Peter, post wrote it, Mr.
Sorry,
Wali.
where are you looking now?
I'm behind tab 31, my lady.
Behind tab 31. Yes.
Yes. And the
Rohit is Walia, is he?
he's
Yes.
Yes. And your Lordship may also have picked up that the document I just referred to, 91, refers to the cross pledge.
Yes,
Which we
I
were
have.
discussing a moment ago. This email again from the second from the first defendant, Mr. Nair, to the second defendant says, post Rohit, so that's Mr. Walia's meeting Mr. Al-Khorafi in London last week. He's the first one. We had received 10 million into Mr. Al-Khorafi's account as collateral. So you've got, in terms of the content of the information, it doesn't greatly enhance that, but it gives you documentary disclosure of the purpose and application of the 10 million. Of course, the claimants well understood that already at this point, this was disclosed in August 2012, that it was the defendant's case, and that Mr. Wali's evidence would be that to that effect, that this was for a margin call and was as collateral, because he'd already recited in the defence under a statement of truth what he was going to say about that. And of course, what then happens, and I'll come to the RFI quite soon, what then happens, we're just on the way there, is that as matters roll on towards trial...
There was no actual margin call made.
No margin call made, which is an important point when we come to authority. There was no margin call actually made. What the complaint is that you lied to me to avoid making a margin call. You lied to me, telling me this was to look good, so you didn't have to make a margin call, which would have exposed the deficiencies in the investments, because they were loss-making, you needed margin. So, in fact, the case is you didn't make a margin call at that point. They made a margin call shortly thereafter, but not at that point. And so all this red herring about whether Mr. Wali had authority to make margin calls for the second defendant is completely irrelevant, because that's not the case. The case does not depend on his authority to make a margin call. Their case is he didn't make a margin call. Their case is he made a fraudulent misrepresentation in relation to these investments, or in relation to the money that the application to 10 million. It wasn't, their case is not that he required in any way to have authority to make a margin call. It's a complete red herring. And another way in which the judge fell into error. So I was going to roll the chronology forward, and my lord, I'm coming to the RFI on the very next page of my notes. I do promise. But what happens in between is that as we roll on towards trial, we get trial witness statements exchanged, and which give us confirmation that the claimants well understand the case that the defendants are making under statements of truth. And we can see that if we pick up bundle 3 from below, and if I could start, there are 3 witnesses for claimants who address this. The first is Mr. Noor, and he's behind, in bundle 3 behind tab 52. Thankfully, all of these statements are in bundle 3, so we'll only need one bundle for them. Mr. Noor, who's the first claimant's office manager, his evidence is at bundle 3, tab 52. And this is the evidence served for trial. So this was served in April of 2013. And at page 1204, paragraph 42, this gentleman, one of the claimant's witnesses, says, 42, page 1204, I understand that the defendants allege that by the end of August 2007, the collateral in the account was in shortfall, and that as a result, Mr. Rafed, as the first claimant, paid a further 10 million to the bank. That is not my recollection of events. Now, so one sees the claimant's witnesses telling the reader what they understand about the case being made and what their response to it is. And he then goes on to say, well, this is my recollection. And if we look at Mr. Taha, the claimant's accountant, he gave evidence at trial. He served a witness statement, which is behind the next tab. His witness statement for trial, and if we look at page 1236 of Mr. Taha's statement, we get at paragraph 86 this, where he says, page 1236, tab 53, I understand that first defendant's internal documents suggest But I had a call with Mr. Mayor, Mr. Khorafi, in August about a margin call. I was not involved in any such call, and there was no suggestion at the time there was any margin call on the account. No suggestion at the time there was any margin call on the account, and he's also been directed to the document. And then finally, the claimant's evidence himself before trial, first claimant, that's behind tab 54 in the same bundle, bundle 3. And one gets there on bundle page 1282, paragraph 88. So 1282, paragraph 88. His evidence about what was said in the telephone call in August 2007. This was the evidence that Deputy Chief Justice Chadwick later accepted after the liability trial. And he says, this is recounted in later judgments, but he says, in around mid-August 2007, Rohit called me on the telephone. It was unusual for him to call me from time to time. Sorry, it was usual for him to call me from time to time. I was in a car in London at the time with Mohamed, and was using a hands-free headset. Rohit asked me whether I'd used all the 35 million that the bank had advanced to me the previous month. He asked whether I was willing to invest a further 10 million. He said it would make me look good in front of the bank if I was continuing to invest money, in particular to enhance this position before senior management in Switzerland. He also said it would be good generally to my relationship with the bank, to ensure that I was a special client. He said that in the future this would also mean those at the bank would look at the relationship favourably, put in a stronger position. And dealing with my interests, for example, and he gives some examples. And then 3 lines up from the end, since I had not used all the 36 million, I was happy to put some of that money back into the bank Sarasin, my client. I told Rohit that I would do so. At that stage, I was unaware of any problems with the account and thought Rohit and bank Sarasin were fantastic. I was happy to do what I could for Rohit at a personal level. I liked him very much, appreciated, etc., etc. And then at 89, I understand the defendants now allege that the purpose of this call was to discuss a collateral shortfall on the account and to call for margin. I did not know what margin was until the bank made margin call in September 2008, so I dispute that there was any mention of a collateral shortfall or margin at this point. So he specifically addresses the margin call case in his witness statement for trial, so he's well aware of what the case is.
So when was the witness statement made?
April of 2013. So this one's on the 4th of April 2013. So we're.
And this is the point where the Deputy Justice team said, well, this was the point where they ought to have appreciated it and made their application to amend.
Yeah, so he placed the hypothetical application in April, no doubt because of the exchange of witness statements. But of course, one sees from the context of these statements that they, on the material they already had before exchange of witness statements, one can see what the claimants appreciated. Because they have set out their understanding of the defendant's case and actually expressly address it. So before exchange of witness statements on the material they already had, they knew the case they were meeting.
But it need not have been very long before the exchange that they understood it.
Well,
I mean, March, February.
Well, my lady, that may get started.
I don't know how people practice here, but generally speaking, as far as I am aware, the understanding of cases comes just before deadlines, when you have to prepare these things. And then you work on it intensively, and you realize what you've got.
Well, you have to ask oneself what changes from at any given point about the state of their knowledge of the case and the bank's the purpose of the 10 million and so forth. Because if you go back to the first defendant's defence, you go to the second defendant's defence, you go to the disclosure, the claimants, taken with their lawyers, have the requisite information. And as I mentioned a moment ago, if it is through, for whatever reason, we haven't had a waiver of privilege in this case, so we can't investigate the question of whether this claim was tactically held back, or whether it was a mess-up that the claim was not brought. It should have been brought in the state of the information, but was not brought. Yes, and if it's the fact that there's some mismatch between the lawyers and their clients, then I'm afraid that's not something for this. It doesn't prevent it being an abuse, because abuse can happen if a claim is not brought through inadvertence or failure to liaise on one side between representatives and their client. There is.
But I mean, the significance of this could have escaped the lawyers, who would not have the information that the claimant had about what he had been intending to do with the money, and if he had not been asked to put in this margin call, or to stop the margin call being made.
Well, it is possible that you may have a mismatch between what the lawyers know and what the client knows. But obviously, taken together, they have the ability to work out that there's a deceit claim to be done.
I understand that. I mean, that's theoretical, isn't it?
Well,
I mean, in theory, yes, everybody, if there was a perfect state of knowledge, they would have had that ability. But if Mr. Khorafi did not know precisely what Mr. Sawalehi was saying until he came to prepare his witness statement, then he would not have been able to reflect on the circumstances of that time, what he was going to do with the money, what he was prevented from doing with the money, and what then the consequences were.
well,
I mean, we are applying hindsight now
we are,
and saying that they should have known all this, but the pieces are with different people.
the pieces have gone at least to Mr. Al-Khorafi's legal team, and obviously at some stage before it.
But Mr. Al-Khorafi's legal team was concentrating on the wrong selling and the breach of various banking regulations, things related to the start of the relationship or the start of the investment, and not, I mean, what happened later is not quite as important.
Well, they
in
have.
that context.
They're concentrating on a number of things, but they obviously have the first defense pleadings about those conversations in August 2007, right from December 2010, which they can put to their own client, of course, because right from 2010, under a statement of truth, you saw what Mr. Alia was saying about the August, about the case. And they
But the problem is, what is the legal significance? They might show it to the client, or they might look at it and not draw the client's attention to it in particular, because they did not understand, or they did not have the information to realize that this could herald a new claim.
The lawyers have to be taken to understand what the law is, and the law of deceit and so forth.
No, but I'm not, of course they know what the law of deceit is. I'm just talking about whether they knew that Mr. Al-Khorafi had other plans for the money. He diverted those plans, he lost, and he diverted the money. He changed the direction of the money under misunderstanding or misrepresentation.
You may come to this point later, my lady's point, in the context of damages, because we know that the Deputy Chief Justice Chagrin wasn't going to allow in a whole lot of other material about follow-on losses, so that everybody had in mind not just the loans that were funding these investments, but the knock-on effect in relation to extraneous loans. And I, for my part, would like to know how that ties in historically with this, at what point the timing emerges on that.
on the losses.
on the losses point, because
Yes.
it's where I began in my first preliminary questions to you about the extent to which the quantum that's now being put forward was in fact a quantum that was open to be put forward in the first place on the same knock-on basis, if I can put it that way, albeit without a deceit claim.
Although, in fact, there was a deceit claim already in the first
Well,
act.
no doubt you'll take us to that.
It could have been pleaded on the fraud measure as well, which is a point I'll show you later. But just, and I will come to, I'm going to come to the losses point
Sure.
when I've dealt with, as it were, the deceit liability case point. But just on your ladyship's point, perhaps I can break it down this way. I mean, I mentioned that going back to Henderson days, a party may be guilty of an abuse if a failure to bring forward the case is deliberate, or even if it's a negligent, inadvertent, or accident. I think those are the words used in the case. Now, if Mr. Al-Khorafi is going to effectively blame the lawyers for failing to explain the position to him, then that's obviously got to be done elsewhere. As to your ladyship's point about, well, what if it all didn't fall into people's radar until witness statements were being prepared? Well, you've got to remember that the conversations in August are said to be, by the claimants, to be a central part of the case. They're so central and essential that they're now claiming issue stoppers in the 2016.
Sorry, essential part of this case or the previous case?
No, the previous case, because it was my friend's submission below, quite a strong submission below, I think Mr. Fraser's submission below, that they gave rise to, and in their pleadings, as I'll show you, that they gave rise to issue estoppels. And of course, issue estoppels only apply to issues that were fundamental or essential for the judge's decision in the original action.
And why were they supposed to be fundamental for Justice Chadwick's decision?
Well, in a sense, that's for the claimants to explain, because we are disputing that if this action goes forward, that they are issue estoppels. We say that they're subsidiary or collateral findings. So there will be that dispute down the line. That's part of the prejudice argument. But I think what the claimants are saying is it went to the question of whether the claimants would have been alerted to problems with the loans in the first action, and that therefore that makes them of some central importance. And I think there was also an argument put forward by Mr. Fraser in the first instance about being relevant to the claimant's leveraging strategy, which if it's important, no doubt the friend will explain. But I think it's said to be central by the claimants to be central because of that, because of the, as I understand it, the potential for the problems with the loans to have come out at an earlier time.
Yes.
So if the conversations in August 2017 are central and essential parts of
August
the case,
2007.
2007, I do beg your pardon, a little jet lag creeping in there. August 2007 was said to be central or essential parts of the reasoning, then of course it's something they should have been focused on. And of course there were pleadings to be looked at, there was disclosure to be looked at from August of 2012. And perhaps, well, I should just also say this, that the first claimant, the claimants had a sophisticated legal team throughout, with a large counsel team. And but effectively, they've got the information from December 2010, at least by February 2012. And whether the omission to bring the case forward is tactical or is a mistake, we can't investigate because there's been no waiver of privilege. But if you are going to make a case that says to escape an abuse finding when all the information is there on your side, you're going to have to do better than just not waive privilege and just make a bold assertion that appears to be inconsistent, as we'll see, with some other information, further information you've shared in the case as well. And perhaps it's a good time to go to that, my lady. I'd shown, I'd shown at the court, I think, the extracts from the claimant's trial witness statements. Now, when the current proceedings started, the second defence, my client and the solicitors, made it very clear that their immediate focus was on the abusive character of the proceedings, sent letters to that effect, and they also served a request for further information, which if you put bundle 3 away and take out bundle 1 from below, is the request is behind tab 6, but the answers are most of those, which are behind tab 7. The request I mentioned in passing, because of course it was served without prejudice to any application to strike out. That was on page 64, but the reply is at tab 7, and it's request 13.2 that we're concerned about. And you'll find the answer to that's on page 89. And this is the date of this document is of some significance. The date, if you could just perhaps keep your finger on page 89 and then look forward to 111, you'll see it was started on the 11th of May 2017. So some 3 months before the evidence that the judge accepted, the first claimant's evidence of the application that the judge accepted, so this was served in May of last year. And it's also served under a statement of truth, which says, on page 111, the claimants believe, not Mr. Bowden, but the claimants believe the facts set out in this response to the second defendant's parliamentary request are true, and duly authorised to sign the statement of truth on their behalf. And what it says, back on page 89, I did show you the request. The request I should show you was on page 88. That's request 13. When and how, page 88, when and how did the first claimant first become aware of, and then 2, the alleged fact that the 10 million stock was in the margin call made by the second defendant? And the answer given to that was on page 89. At 13.2, the claimants first became aware that it was the defendant's case that 10 million was sought in relation to the margin call when the defendant's defence of the 2009 proceedings was served in February 2012. The claimants did not become aware of the full facts until cross-examination. Now, they refer to the defendant's defence. February 2012 must refer to my client's defence, but of course, exactly the same information was available from the first defendant's defence back in December 2010. And of course, this document must be an implied acceptance that awareness must also apply to the earlier defence, because it's the same information. Now, as to, I think it's been said, and this is perhaps apropos of my lady's issue about if there's a difference between the lawyer's knowledge and the client's knowledge. I think it may be said by the friend that you have to distinguish those two things, and Mr. Al-Khorafi may not have appreciated things that his legal team might have appreciated, and that this RFI only addresses itself to the latter of those questions, that is to say, the lawyer's knowledge, not that of the client. But first of all, there's the point that shouldn't matter, which I've made. I don't want to put too much length. But there's also the point that is not what the RFI statement of truth says. Because the RFI statement of truth on page 111 says the claimants believe the facts stated to be true, and I'm duly authorised to sign. It doesn't say I believe the facts to be true, nor is that what the reply itself on page 89 says. It says the claimants first became aware. That's what the reply itself to the question says. And moreover, you have to consider what under the rules it means when a legal representative signs a statement of truth for a client. And I don't know if the court has available the RDC as far as this is concerned. If it doesn't, I'll provide copies. There may be a reference in the authorities fund already. It's 22. But I'm just going to go to RDC 22.2. Big one, 22.21. There may be an authorities bundle reference which I'm trying to chase down.
In a case of this magnitude, it would be professionally negligent not to have passed this in front of the client for the client's approval. And I think the court's entitled to proceed on that basis, right, regardless of the statement of truth and all that entails.
Well, we would of course say so. But for completeness, if I start reading, and we will supply this if it's not already in the authorities bundle, the RDC specifies in 22.21 that there are parallels in the CPR, where a party is legally represented, the legal representative may sign the statement of truth on his behalf. The statement signed by the legal representative will refer to the client's belief, not his own. This is, in my version of the rules, I think it's page 229, but you mentioned there a different version. But so it refers to the client's belief, not his own. In signing, he must state the capacity in which he signs and the name of his firm are appropriate. And then at 22.22, where a legal representative has signed a statement of truth, his signature will be taken by the court as his statement. And then one, that the client on whose behalf he has signed had authorised him to do so. Two, that before signing he had explained to the client that in signing the statement of truth he would be confirming the client's belief that the facts stated in the documents were true. And three, that before signing he had informed the client of the possible consequences to the client if it should subsequently appear that the client did not have an honest belief in the truth of those facts. So it couldn't be clearer. Not only are you signing to the client's belief, you have to tell the client that, explain that to the client, and warn the client of the possible consequences beforehand. And the court will take your statement of truth to that effect. And it's just not good enough to assert on submissions without waiving privilege, without putting in further evidence, that actually this RFI refers only to the lawyer's knowledge, it doesn't refer to the client's knowledge, because that's, under the rules, that's not right. That's not the confirmation that's been given. And if you're going to start to try and go behind that, you certainly shouldn't be able to go behind it without making a full waiver of privilege to explain what happened in the making of this document. And what is not right is that we should all be faced with years of further litigation because on submissions, counsel is able to go behind what the rules say, what the statement of truth said.
We would ordinarily take a short break in the middle of the morning, so when you come to a convenient point, we'll take 5 or 10 minutes out.
My Lord, I think it is a convenient point. I was going to turn to the second reason why the judge delayed the hypothetical case management conference, which is the authority one. So we're going to move on to that.
All right. Well, we'll take 10 minutes now, if we may. Thank you very much.
All right.
One of the dangers of having breakfast, of course, you
realise there's a point we didn't make it on the ground of the appeal I had just been addressing. But in fact, in this case, there are 2 points I'd intend to make. And if I could just make it briefly and then move on to the authority issue. Your leadership asked me about this question of, well, potentially Mr. Khorafi didn't wake up to what was in the defence or what was in the disclosure until relatively late in the day. And I made the point that actually, even on the claimants case, these conversations are very important. And if it was in bundle 11 from below to from the bundles below to the transcript of the hearing before the Deputy Chief Justice, which is under appeal, and I can invite you to tab 117 of that. So bundle 11 to tab 117. The document we're going to is the transcript of the hearing below. And I was going to show you the case put by the claimants on that occasion by Mr. Fraser. And once you're there, if I can invite you to the transcript, using bundle number 5432. And these are in Mr. Fraser for the claimant's submissions. And he says at 5432, line 5, the August 2007 conversation was significant to this issue, because if he, that's Mr. Khorafi, was told of the margin call in August 2007 and paid it without demur, to use a phrase from the defendants in these proceedings, it would support the defendant's defence that the first claimant was aware all along products were risky. So that's why Mr. Fraser for the claimants is saying the conversations were important. And he then goes through the plead evidence for quite a number of pages, right through to page 5456, to make his point good. So they plainly regard it as important because there are 14 pages of transcript spent on it. And it concludes at 5456. And when you get there, it says line 11. Well, Mr. Fraser says this: so your lordship sees that what the judge was faced with, that it was, so what happened with the conversations of 15 August features as an essential step in the overall defence of both defendants. An essential step in the overall defence of both defendants, namely being integral to their key claim that C1 was well aware of the risks of the language product. So they're basically saying it was a central feature of the early litigation. And they're spending a lot of the transcript seeking to make that point good. So that was the first point I wanted to make on the previous ground of appeal. The second is this, that one of the things that was said against us in the permission hearing was that this was, before the judge, was a summary process, and in some way that made it all right for him to accept the claimant's evidence at face value. Now, it is, of course, well established that even in a summary process, the court is not obliged to accept everything that's said in a witness statement at face value and without analysis. A factual assertion may have, of course, no substance. It may be contradicted by the contemporaneous documents. It may be plainly incredible. And so far as that's concerned, if you put away bundle 11 and take up the authorities bundle, the first authorities bundle at tab 26, one gets in this court in fact, the Deputy Chief Justice recited these very principles in the Papadopoulos case behind tab 26. You should there find the state of Christos Papadopoulos against Standard Chartered Bank, a decision of Deputy Chief Justice Steele himself. And he adopts the summary principles of Justice Roger Giles, who themselves have been taken from a number of English cases. But at page 515, through to 515, that's to say paragraph 16, the judge says there was, as might be expected, no dispute in the correct approach to an application for immediate judgment. The issue was considered in the judgment of Justice Roger Giles, and he summarises the principles, including all of the page at the E. The court is not required to take everything the party says in its witness evidence at face value without analysis. Factual assertions can have no real substance, particularly if they're contradicted by contemporaneous documents, which of course is what we have here. And the I noticed on the front list of authorities for this hearing, there's a case called Long and Farah, and because we don't have a further skeleton from the front, I may have to come back to that and reply if it becomes relevant, a decision of Mr. Justice Ryman, which he may seek to rely on. But of course, Mr. Justice Ryman in that case was dealing with effectively a swearing match between two witness statements, one saying X and one saying Y, and the criticism there was that the judge below, the deputy judge, a district judge, beg your pardon, had just chosen between them. And of course, that may be impermissible without cross-examination, but that's a long way from this case, where you have contemporaneous documents from the claimants' side themselves contradicting, and you have the record of what actually happened in the 2009 proceedings. With that, my lords and my lady, I was going to go to the ground of appeal 6, which is the second key reason why the judge delayed the hypothetical case management conference, because he said that the claimants couldn't plead the requisite authority of Mr. Walia until after Mr. Walia's cross-examination at trial. Mr. Walia was a first defence employee, and the judge said, well, you couldn't plead the authority to fix the second defendant with that till after trial. And what the judge said about that is in paragraph 28 of his judgment, back in the core bundle behind tab 1. And I'm sure you will have read this passage in paragraph 28, and I have to confess that I have some difficulty following the logic of the passage in paragraph 28 myself. But there are, I would suggest, a number of problems with this analysis to the extent that one can follow it. The first problem is that the particulars of claim in the 2009 proceedings had already pleaded that Mr. Walia acted as agent of the second defendant in all its dealings with the claimants, including in respect of allegedly fraudulent misrepresentations, negligence, and so forth. And I showed that to the judge below. And that pleading you will find in bundle 4 behind tab 57 of the bundles below.
Sorry?
Bundle 4 and tab 57.
Thank you.
Now this is the re-amended particulars of claim in the 2009 proceedings. And page, if you look forward to page 1683 of the bundle, one should find out here paragraph 122. This is the claimant's case in the 2009 action. And at 122 they said this: further alternatively, in dealing with the claimants, Sarasin Dubai and Mr. Walia and Mr. Nair acted as agent for Sarasin Switzerland, that's my client, the second defendant. Accordingly, pursuant to Article 32 of the Code, their actual admissions are to be imputed to Sarasin Switzerland, the second defendant, which is therefore liable as a matter of Swiss law for the wrongs set out below in this re-amended particular claim. And in particular, the misrepresentations set out below in paragraphs 123 to 127. And if one looks at what those are over the page, page 1684, one sees a heading, Misrepresentations by Sarasin Dubai. And these are misrepresentations that we are, my client, said to be liable for in the previous paragraph. And you see what those are. And you see it, paragraph 123, set out above Sarasin Dubai as the first defendant, stated at the meeting in April that these two claimants would never lose money on capital protected investments made with the first defendant and the second defendant. Repeated this statement subsequently through Mr. Nair and Mr. Walia, including at least set out part of the media on 22nd June, as well as on other occasions. As to these statements, which they call capital protection statements, And if one drops down the page to sub 4, third line, in view of these facts, of those facts of the level of risk involved in the products and the investment structure which Sarasin Dubai went on to recommend through Mr. Mayor and Mr. Alia, it and they could not have believed and did not believe the capital protection statements or company representations were true. On the premises, the capital protection statements were made fraudulent. 5, alternatively, in view of those matters, the first defendant through Mr. Mayor and Mr. Alia and Mr. Alia had no belief in the truth of the capital protection statements or the accompanying representations, or were reckless as to whether or not they were true. In the premises, the capital protection statements were made fraudulently. Not only is there already a pleading of that the second defendant is liable for Mr. Alia's actions, but also liable in respect of fraudulent misrepresentations. Just to conclude on that, at page 1691 of the bundle, moving forward, it said, will we find paragraph 129? It said, in the premises, the first defendant under Mr. Alia and Mr. Nair provided their services for the second defendant under the Swiss Financial Services contract under a relationship of service and are acted as the second defendant's agent in relation to the transactions complained of in this really amended statement in this really amended statement of claim. So, in my submission, the very case which on this application the first claimant said he could not advance until after cross-examination of Mr. Alia had actually been pleaded already long before trial. And it's also the same case of authority and vicarious liability that is now put in the 2016 particulars of claim. Because if one puts away bundle 4 and looks at the current particulars of claim, the bundle...
It's really paragraph 130 rather than 129, isn't it, there that you want?
Just going back to that. I had 130 marked,
because that's the one that deals with the deceit and
yes,
misrepresentation.
it makes a specific point that they're not strictly liable in deceit and misrepresentation. The first 2 lines.
Well, that's defendant 1 and defendant 2 vicariously liable in line 3 and 4.
Yes. Yeah. So it's the very case that that the claimants are saying on this application we couldn't make till after cross-examination of Mr. Welling, and it's pleaded in the broadest terms, and it's that broad authority vicarious liability case which is also put in the Claimants Act. It's the same case that they were already pleading in the 2009 action. And for that I was going to go to the current particulars of claim. And those are in bundle 1 from below, paragraph tab 5.
But, I mean, if you look at the particulars, which are on the previous page, 1 to 8, they are dealing with different statements.
I appreciate that the fraudulent misrepresentation was a different misrepresentation. It's right. But what is being said in general terms is that UD2 are liable for fraudulent misrepresentations in relation to these notes or investments made by Mr. Alia of the first defendant in clear terms. And that's the case that is currently being made in this action, and didn't depend on anything said by Mr. Alia in cross-examination in order to make that case.
That is the question of the responsibility for Mr. Alia's statements. But the content of the statements was different. So you're saying that's irrelevant?
Well, if you look at the breadth of this pleading, our current statement must fall within it. It's a broad, general plea of liability for fraudulent misrepresentation, deceit and misrepresentation. on the part of the second defendant. It happens to relate in this case to the capital protection statements and other statements.
So basically what you're saying is any claims that you have for fraudulent misrepresentation could have been brought then, or should have been brought then. If you had a claim for fraudulent misrepresentation, even though you weren't aware of it, since you've already brought one claim for fraudulent misrepresentation, the second claim would be covered. Is that what you're saying?
Well, no, what I'm saying is that the claimants were not handicapped in bringing forward their new deceit claim by an inability to plead that Mr. Alia made a representation on behalf of my clients.
So was that what the judge said?
Well,
I didn't think he put it like that.
well, it may be best to go back to what the judge did say. Because he, at 28, back in bundle, the core bundle, page 13, he says that a plea of fraud against Mr. Alia is one thing. In order to plead a case of fraud against the bank, that's my clients, it was necessary to rely on credible material support proposition that Mr. Alia made a fraudulent representation on behalf of the bank within the scope of his authority. In that connection, it's right that the particular claim in 2009 included the continuing attention that Mr. Alia was acting as head of the bank is dealing with the first claimant. But this is rigorously challenged. As the first claimant submits, there's something surprising about the suggestion that the first claimant also was sufficiently confident of the existing extent of the agency, including authority to exercise the contractual right to make margin calls prior to the trial, so as to expect to resist successfully the strikeout application in this regard. In regard to the fraud allegation, it was only in the course of his cross-examination that Mr. Alia outlined his role as customer relationship manager in giving forewarning of the margin call prior to a formal margin call, short leaving aside the indicators and formulating a concert. I'm not persuaded that the new claims could have been treated prior to the trial. Now, that seems to be saying that it was necessary to have the evidence Mr. Alia gave at trial about his role as customer relationship manager in giving a forewarning of a margin call. There's also a reference been earlier to the authority to exercise the contractual right to make the margin call in order to plead that the second defendant was responsible for this deceit. And my current point, first of all, and I touched on this earlier, that's incoherent as a reason because the current claim is not dependent on Mr. Alia having specific authority to exercise a contractual right to make a margin call or a specific authority to give a forewarning about it. But the point I was making, I was on, was that authority and liability of the second defendant had already been pleaded in the broadest terms in relation to the fraudulent misrepresentations made in this banking relationship, and indeed in relation to the notes and investments. So they had already. The other point that one could perhaps get out of that following that exchange is that obviously, for all that the claimants now want to rely on professional rules about pleading fraud and so on, they obviously had no compunction about accusing Mr. Alia of dishonesty in any number of other misrepresentations so far as the 2009 proceedings were concerned. So it's a general plea of authority, and it's a general plea. It was a general plea of authority in the 2009 proceedings. It's a general plea of authority in the 2016 proceedings. I just show you how authority is pleaded there, and it's effectively the same overall plea of authority. It's not said to be dependent on any specific authority or anything Mr. Alia said in his cross-examination at trial. And that is back in Model 1, Tab 5, and paragraph 11 of the current particulars of the and the authority here is pleaded at paragraph 11 on page 20. That's it. The basis on which my client said to be liable for Mr. Walia's acts, it says that my client is vicariously liable and or directly liable for the deceitful statement and the replied deceitful representations made by Mr. Walia as its agent and the losses flowing therefrom. So it's a broad plea of authority, general plea of authority, not dependent on anything that has emerged from cross-examination or any authority to make margin calls or any authority to forewarn about margin calls. And we asked about the case on authority in it's a further request for further information. And what we were told behind tab 7 again, we looked at this a moment ago in a different context, but behind tab 7, page 88, we were given an answer about the authority case, which is in a question and response 10 to the request is at 87 through to the page, nearly through the page, number 10. What, according to the first claimant, is the scope of Mr. Walia's actual implied and ostensible authority under and then the different systems of law are identified? And then at page 88, we get it down to 10. We get this is a repetition about foreign law. And then without prejudice to this, in respect of each of 1 to 4, the claimant's case that Mr. Walia had actual and or implied and or ostensible authority in respect of all matters connected with the provision of advice and information to the first claimant in relation to the notes generally, lending generally, and operation of the claimant's accounts generally, including but not limited to information and advice in relation to the state of accounts and any liabilities which the claimant incurred and therefore might incur to the second defendant. So it's an entirely general plea again, same as in the first action, and in fact they go so far, if we look forward to request 26, to say that authority, at least ostensible authority, is the subject of an issue of estoppel from the first action. And that's on page 93, where in response to request 26, they say at the foot of 93, Bank Sarasin is the first defendant, actual and or ostensible authority extended to all matters connected with the provision of advice and information about the notes generally, about its employees and agents, including Mr. Walia. The manner in which the ostensible authority arose is res judicata between the claimants and the second defendants, C, and they quote the liability judgment. So they're saying, they go so far as to say, actually your authority is res judicata from the first proceedings, the liability judgment. Now, it's legitimate to ask how, if the claimants could not plead the relevant authority without Mr. Walia's cross-examination, i.e. till after trial, in the first proceedings, how on earth they managed to bank themselves a tidy issue of estoppel on this very point? And of course the answer is that they said they've already pleaded it before trial. So that's a pretty major problem with the judge's analysis. And the next problem with the analysis is the judge's analysis is, well, I think I've made a point that it's inconsistent with the comprehensive pleas of authority that are made elsewhere. But it also suggests, this is a point we touched on before, it analyses the case being now being put as being dependent on showing somehow that Mr. Walia either had authority to make margin calls or to give forewarnings of margin calls. And that's just a wrong analysis of the case, because the 2016 claim does not depend on Mr. Walia having authority to make margin calls. In fact,
the case is that he lied to avoid having to make one. And in 2016, the case in 2016 and 2016 proceedings is that Mr. Walia made fraudulent misrepresentations in the course of the discussions he was having about investments with the second defendant. That's the case.
The judge isn't relying on that. The judge is relying upon authority to give a forewarning of a margin call as opposed to a margin call per se.
Well, it still doesn't depend on that, my lord, because if you look at the pleading from the 2009 proceedings, it's pleaded in the widest possible terms that anything Mr. Walia said about these investments, you're liable for if it's wrong. This smaller plea of these specific authorities is actually encompassed in the larger general plea of authority and vicarious liability. It's already encompassed by that. And of course, you can see that this is a fig leaf, because when they come to plead authority in the 2011 action, there's nothing about what Mr. Walia said in cross-examination. They say there's an issue of estoppel on it. So all of that is inconsistent, and the judge's analysis we submit is also, if and to the extent he's saying the case depends on authority to give a forewarning of a margin call, and the ability to plead depends on that, the case depends on that, it doesn't. They'd already pleaded the case in wide enough terms of authority. And it's probably, well, I think you have the point. If we looked at the particulars of claim from the 2016 proceedings, in paragraph 68, where the claim of deceit is there set out, and the claim is not that you deceitfully made a margin call. The claim is that you actually told a lie because you didn't want to have to. Now, there's one other point worth making in this context, which is that it has been the claimant's case since the early stages of the 2009 proceedings that all communications between the claimants and defendants travelled through Mr. Walia or Mr. Nair. That's been their case consistently throughout. They had some success with that in the Court of Appeal and the jurisdiction application, because the Court of Appeal accepted that in the judgment on jurisdiction. It's probably unnecessary to go there. And that's how they put their case at trial. So when Mr. Walia came to give evidence consistent with that he was had a conversation about a forewarning of a margin call, that was a completely unsurprising piece of evidence. Now, I should just, before I move on, address some of the points made against us on this from the permission application or elsewhere. I think in the claimant skeleton for the permission application, there's an attempt to say that the judge in paragraph 28 is making a distinction between oral and written margin calls. Now, no doubt that point to be developed if it's pursued, but there is not a hint of that in paragraph 28 of the judgment itself. And nor does the deceit case in any way depend on establishing that Mr. Walia had authority to make oral margin calls. Well, perhaps no more needs to be said about that. In fact, I think I can probably conclude on this ground. So if we are right about what we say about grounds 5 and 6, then in our submission the judge made a fundamental error in placing the hypothetical case management conference as late as April 2013. If, as we say, the new deceit claim had been pleaded as in accordance with the ALDI guidelines it should have been at the correct time, which at the latest would have been the middle of 2012, then, because I referred you to a treaty which indicates that the application should be made as soon as the claimant should have appreciated the defendant's potential liability. then it would, of course, have been much, much easier to case manage at that time. Now, I'll go, I know Your Lordship is keen to hear about the losses, and I'll go to that next, which is our ground 3 of our appeal notice, which, of course, again feeds into the question, also the question of what should have been before the court on a hypothetical CMC if the claimants had brought forward their whole case when they should have done. Now, I showed the judge by reference to the claimant's own pleaded case in the 2016 proceedings that all the real estate losses now claimed in 2016, said to be about $1 billion, were known about long before trial in the 2009 proceedings. And indeed, almost all of them could have been quantified by 2012. And that wasn't seriously challenged below. And indeed, it is, of course, supported by the judge's own finding on striking out negligence and breach of contract claims, which he did in his judgments at 37 and 38, because it's implicit in that finding that he has necessarily accepted that there was awareness of some substantial damage from at least 2010. Otherwise, he couldn't have struck out the negligence and breach of contract claims, because the rate of claims started in 2016. There's quite a number of materials that one could go through as far as this is concerned, but the quickest way to look at it is probably from the 2016 particulars of claims, so the claimant's own pleading in 2016 of the real estate losses, which is back in Bundle 1 behind tab 5. And for this purpose, I was going to go to, first of all, within the tab, so this is the current pleading, page 40, paragraph 82. One sees that in June 2009, as a result of Mr. Khorafi being unable to make necessary repayments on behalf of Rafed, that's his property company, which was a consequence of Bank Safra Sarasin deceit, breaches of duty, hereof ABK, they're making the loans on the property projects, ceased allowing Rafed to draw funds, cutting off the further funding of the project. So ABK's lending on the tower project ceased.
Sorry, where are you?
I'm in paragraph 82 already.
82.
82, page 40. My intention here, Hamad, is just to go through some portions of the claimant's own pleading, which show you what they know about the losses they are suffering. And so it effectively pins them with knowledge of all of these losses significantly before trial in the 2009 proceedings. And so we see that ABK has ceased to allow the property company to draw funds in June 2009. In the next paragraph, 83, on 1st November 2009, ABK attached by way of execution funds from any other bank accounts held by Rafed and Mr. Khorafi, companies associated with him. This actually caused ABK to reduce credit facilities to Mr. Khorafi. Then 84, on 10th November 2009, ABK cancelled the Rafed loan, demanded immediate repayment. So he's basically lost his finance for the project at that point. And demands repayment of the loan. And then at 87, construction of the tower halted at the end of 2009, with the structure only 5 floors in height. And then as far as the Al Samir project is concerned, one looks forward to 101 on page 43. One sees on 11th April 2010, the Salmia agreement was terminated by agreement to Rafed and landlord. So the agreement for his Al Samir project is terminated in April of 2010. And there are other, in fact, part of the 1 billion loss is said to be that he was going to float all this property enterprise through a listed company. And we know that that listed company from this pleading was actually delisted. If I look at page 44 and 105,
RAC, that's the listed company, which delisted on the 19th of March 2012, so that only certainly, probably before giving up that project. So, I mean, the point of doing this is to show that all of these real estate losses were known to the claimants significantly before trial in the 2009 proceedings. That wasn't, the proposition was not seriously challenged below. And I made the point to the judge that the...
So you would say they were known to the claimants by mid-2012?
Well, and most of them
because you say the application should have made then.
Yes, and certainly by mid-2012. And in fact, most of them are known earlier. Most of them are known in 2009 and early 2010, as I showed from the earlier points of the proceedings. Certainly all the tower losses were known a lot earlier than that. So but there isn't really any excuse for failing to plead the tower losses from 2010. There isn't. And Al-Salmiya from April 2010, because that's when the agreement was terminated. So there was no excuse for holding back the real estate losses. And indeed, when the claimants tried belatedly after the liability trial to get some of the tower losses into the first action, the court refused. So it was too late. It hadn't been a split trial, and you're now too late. And which it shows that whether or not that amounts, that means that this is now a collateral attack on that decision, is another debate we could have. But at the very minimum, what it shows is the court, the question of whether the claimants brought their real estate loss claims timorously in the 2009 proceedings has already been answered. The answer is no. They were too late. They were dilatory about bringing their real estate loss claims, and they were refused. Which is part, of course, of the broad merits-based judgment that comes into this abuse application. But the point goes further, because I made the point to the judge that the claimant's case is that all these losses were caused by investments in the notes, and all of these losses could have been claimed in any number of the claims made in the 2009 proceedings. And indeed, of course, that's acknowledged by the fact they tried to introduce the tower losses later on, so they know they could have pleaded them as losses under those claims. So that's effectively an acceptance of that. And indeed, they could have been pleaded on the fraud measure. So it's not an excuse to say, oh, the remoteness rules are different, contributory negligence is different. Because, of course, they were already pleading fraudulent misrepresentations, as we saw, in the first action. So it's their fault they left it to November 2014, some 17 months after the liability trial, to try to get these losses some of them, into the first action. Now, this has a number of further ramifications, because, of course, if the claimants had behaved reasonably in bringing forward their whole case in the 2009 proceedings, as they should have done, the real estate losses would have been part of and included in the 2009 proceedings at an early stage, long before trial. Which, of course, would have made the job of case managing the new deceit claim much, much easier. Because if you ask yourself whether the burden of investigating and trying that claim is, quite a large part of the burden is in the real estate losses, because that's what it may be said would require further disclosure, whether statements, etc., etc.
Well, it's all of the losses, really, isn't it? Because the compensation is going to be the subject of witness evidence. It may be that had there been an express fraud allegation, it would have been explored in slightly greater depth.
Yes.
But realistically, what are we talking about? An extra half an hour or something? I mean,
oh, maybe more than that. There is prejudice here, because there's my clients, represented by the team at the time, did not even cross-examine on this statement at trial. There was a cross-examination, a couple of pages, by Mr. Brindle for the first defendant. But Mr. Black, for the second defendant, did not even cross-examine on the statement at trial.
And of course, you can be quite sure that if $1 billion had been riding on that statement, you would have been cross-examined uphill and down. That's part of the prejudice of claiming an issue of estoppel already. Because if there's an issue of estoppel on that, we didn't even cross-examine, and now we might have to pay $1 billion because of it. And that is a precedent. That is a precedent. The point I was on is that on the loss side, if they had behaved as they should have done, brought their real estate losses forward at the right time, then by the time you get to a hypothetical case management conference in the middle of 2012, the real estate losses are already on the pleadings, there's already been disclosure of those. All you're doing is talking about a deceit claim on another statement in August 2012, in addition to deceit claims already made, which are already going to be part of the witness statements in any event. And yes, there may have been some further work to be done to investigate, because of course, if you've got a deceit claim like that and you're claiming $1 billion, I'm quite sure the defendants would pull up the floorboards to try and find evidence in relation to it. But if the case could have been managed quite easily going forward into a trial in May of 2013, with all issues tried together by the same judge at the same time as they manifestly, we say, should have been. Now, my lords and my lady, just before I move on to Aldi, which I do need to deal with, it's probably an appropriate point to deal briefly with the other connected issue here, which is the collateral attack point, because you have seen that one of our grounds of appeal, ground 9, is that actually trying to claim the real estate losses now is a collateral attack on one of Deputy Justice Chadwick's decisions, effectively a decision to rule out the real estate losses in the first action, which was, we say, treated effectively as a strikeout. And if you're now going to resurrect your real estate losses, you are, in substance, mounting a collateral attack on that decision of Deputy Chief Justice Chadwick. I'll take this as briefly as I can, but I do need to just show you what the decisions are that we're talking about. And those, and the history of this was that after the liability trial, the claimants raised the possibility for the first time, it hadn't been a split trial, of some new losses. And Mr. Justice Chadwick made an order about that on the consequential hearing, which is in bundle 9 behind tab 78. You should find an order of Deputy Chief Justice Chadwick on the 28th of October 2014.
Sorry, can you give the reference again?
Bundle 9, tab 78. Thank you. Bundle 9, tab 78. And effectively, the claimants were asked to be allowed to evidence of these losses. And there was a debate about that before the Deputy Chief Justice. And at tab 78, he made some orders about that and gave some reasons. And on page 4220, so this is after he's given his liability judgment, he says in paragraph 3 of his order, the amount of the first offence liability shall be, B, further amounts to be assessed in respect of, then B2, losses arising out of the claimant's relationship with, that's ABK. So losses arising out of the claimant's relationship with ABK, and that was with respect to the first offence. The second offence dealt with paragraph 5. The amount of the second offence liability shall be, if I go to the top of the next page, B, further amounts to be assessed, including amounts in respect of, and then if you could mark Roman 2, losses arising out of the claimant's relationship with ABK. And then he says it's at paragraphs 7 and 8,
All other claims for interest and damages, including the quantification of interest and the quantification of categories of damage, shall, together with any other claims, be adjourned to be determined. One day hearing to be held on the first available date after 29 January. And then 8, the claimant shall file concerning the defence any evidence in support of their claim of quantum, with a quantum determination order on the back of 7 above, by no later than 4 p.m. 20 November, subject to further order of the court, for which the claimants may apply in writing or draft of further evidence on which they seek to rely. Such evidence shall be limited to evidence of events which have occurred since the 10th of July 2013, being their last day of trial in these proceedings. And he explains that direction at page 4225, where he says, at paragraph 9 in his reasons of 4225, he says the second matter which requires explanation is the restriction of further evidence that I've included under paragraph 8 of my order was forced in the defendant's submission. So that's a submission on our side. This is not a case in which the court was asked to order or did order a split trial. The evidence of which the claimants are entitled to rely for the purpose of assessing the quantum of their claims is the evidence that was before the court of the trial, subject to the possibility quantification may be affected by reason of post-trial events, and for that reason I think it right to restrict the evidence which the claimants may adduce in support of their contentions to quantum to post-trial matters. But I leave open the possibility that there may be some further matters which justice requires the court to consider, and if there is, they can apply writing to rely on evidence, but such application must be made in advance to the quantum determination or to determine such application, the court will require to see a draft at least the further evidence. So effectively, he's saying there wasn't a split trial, it's only post-trial matters you can put in now in quantum, subject to any overriding requirement of justice. And then the way the matter proceeds is that the claimants serve some evidence, including some of the tower losses, which are included in this action. And we have to go to the next bundle, bundle 10, to see how the Deputy Justice addresses that. Bundle 10. Behind tab 92.
Bundle 10.
Bundle 10, tab 92.
And this is?
This is Deputy Justice Chadwick's ruling on the 13th of January 2015. This is after the claimants have served evidence seeking to claim effectively a part of the tower losses, the tower real estate losses, which are also claimed in this action. And Mr. Deputy Justice Chadwick addresses that in paragraphs 23 to 25 on page 4741. And he says in those circumstances, the question for determination of this application is whether Mr. Harper's claim to losses which he suffered by reason of forced sale under order of the Kuwaiti court of the tower was the plot on which the tower was to be built is within the scope of 3B2 and 5B2. I showed you a moment ago of the earlier order. That's to say whether those losses are losses arising out of the claimant's relationship to ABK. In my view, the answer to that question is no. And he effectively holds 5 lines down that that ruling was referring to losses as borrowers from ABK in relation to funding of their investments in the second defendant, not more broadly as the bank funding its broader property developments. And he says in 25, in those circumstances, Mr. Khorafi's evidence contains no evidence relevant to the claims which are to be quantified, and for that reason he excludes it. And there was an attempt made to appeal that, just for the note, at the same bundle at 95, that was, well, actually, I should show you, I should show you tab 95, because 95 is the claimants skeleton argument tried to appeal the ruling we just looked at, and they recognise in their skeleton argument that they've effectively been struck out, because they say so at page 4763 at 41, paragraph 41. They say in their submissions, Mr. Hill QC, 41. Further, the judge should not only have excluded the claimant's claim on this basis, effectively as a strikeout, without going on to address it at the quantum hearing, so as to reach a conclusion on whether there were recoverable losses which have been proved. So they know they've been struck out, and they apply for a permission to appeal. That was refused by Justice Roger Jarvis behind tab 96, and they asked for a reconsideration of that by Justice Sir Richard Field. That's behind tab 99, who also rejects their application for reconsideration. And he says in this regard, which on behind tab 99 is bundle 10, and he says at his paragraph 34, he says, through to page 4813, he says, as to the claimant's remaining submissions, many of them the VCJ should not have excluded RAC 4 as he did, effectively as a strikeout, but should have considered whether the RAFCO losses were recoverable at the quantum hearing. In my opinion, there's nothing in this contention. 28 to Roy, it was a matter of necessary and wholly unacceptable case management, with the object giving directions to the quantum hearing witness to the issues and admissible evidence, and promulgating those directions. The VCJ proceeded as he was undoubtedly well entitled to do by reference to the fact that trial was not minister at trial. The recoverable losses, as identified in his judgments, which so far as they represented the claimants' relationship to the UK, were founded exclusively on losses arising out of the relationship between the UK and the claimants as borrowers from the UK in relation to the funding of the purchase of the Sarasin investments. And indeed, the fact that it had effectively been a strikeout was recognised, I think, by the Deputy Chief Justice himself, that on the costs application, which is at the back of the bundle 104, when it came back before the Deputy Chief Justice Chadwick on costs, he says at bundle 104, bundle page 5086, 38, he says the defendants submit correctly that their applications to exclude evidence were successful in relation to the witness statement RAC 4. They also submit again correctly that the effect of excluding that evidence was to strike out a proposed claim on behalf of the claimants with respect to losses estimated at 37 million or thereabouts, said to have arisen in relation to borrowings by RAFCO, the company under control of the first claimant, from the UK and said to have been guaranteed by the first claimant. That's the. I do apologise.
Just do go on.
104. Bundle 10.
Bundle 10.
Tab 104. This is Mr. Justice Chadwick dealing with the costs of the episode that we just looked at, as to whether these new losses could be claimed. The point of referring your ladyship to this is simply this: that at page 5086 of the bundle, 5086, paragraph 38, he recognises that the effect of his ruling was to strike out those losses from the proceedings. The point on collateral attack is simply this: that the question of collateral attack is it's not formulaic; it's a question of substance. And it may be the case that in form, the order of Mr. Justice Chadwick and the ruling subsequently made were to say, no, these losses don't fall within the order I have made about what evidence you can now adduce. As a matter of form, that's what they actually decide. But as a matter of substance, they are saying, you are too late to claim these losses. There's not a split trial. That's the substance of the rulings. And in my submission, it amounts to no less than a collateral attack on those rulings, to now say, I can bring these real estate losses in these new proceedings. Because it's effectively been decided in the first proceedings that those are losses that you should have been claiming at a rather earlier time, certainly before trial. Now, moving to the ALDI guidelines, if I may.
Before you go there, can we just explore that question a little further? On a mis-selling claim, where the argument is those investments shouldn't be sold at all, and the recoverable damages were therefore to put the claimant back in a position as if those investments had never been made. Am I right so far?
As a broad matter principle, yes.
Right.
No transaction basis.
Yes, exactly. No transaction.
And that was certainly their principal case.
Yes. The effect of the mis-selling case is in the context of seeking the losses which were excluded by the Deputy Chief Justice. The arguments being put was the mis-selling claim meant that monies were tied up which otherwise would not have been tied up and would have been available to the claimant for other purposes in the context of various other projects, in this case particularly the Tower project. Now, is there a difference in the quality or the nature of that claim from that which is now put in deceit for the events in August of 2007, or is it the same in nature, albeit now encompassing a wider area of projects and possible investments?
The broad causation case is the same. It's broadly the same. It's to say there are add-ons for the 10 million because he has to make a leap to say, in the current litigation, to say, if I hadn't put that 10 million with you, then none of this would have happened.
I would have been able to repay other loans, and therefore
I could have repaid other loans.
The other projects wouldn't have folded because I'd have been able to keep up.
So there's a little bit extra on the causation of that, a little bit of extra investigation, but the thrust of the case is still, it's still a case that is in the investment in the notes caused the losses. Now, I have to accept the causative trigger is a little bit different, but not vastly different. It is different, but it's not vastly different, and it wouldn't, it would of course have entailed something of a different investigation, but that doesn't. It doesn't get away from the point that you should, as a party, bring all of your case forward at the appropriate time. You shouldn't be holding any of it back. And had they done that, even in relation to the causes of action they were bringing, when you get to your hypothetical case management conference, the real estate losses are already part of the litigation, and they're not a bar to a case management and deceit claim within the confines of that action.
If one's looking for a differentiation between a claim that's put in deceit and a claim that's put in regulatory terms, which was what the Deputy Chief Justice decided, without at that stage needing to go to the alternative tort claim or contract claim, because he decided on a regulatory basis didn't go there. But the difference which may arise as a matter of law is the test that has to be applied for the measure of damages. But when the Deputy Chief Justice dismissed the Tower project losses, it was, as you say, essentially on two bases. One, you're too late. But only on that basis, really. But he never grappled with the question of whether, in fact, there was a problem of either foreseeability or causation at all.
No, he didn't get into that. No, he didn't. And he didn't regard that as being before him. Well, the first thing one can say is that because, as I showed the logic earlier, there were fraudulent misrepresentation claims being made already, the losses could have been claimed even before that. So that's not necessarily.
Well, that's an interesting point. The fraudulent misrepresentation there was of, quote, capital protection. the put as the usual investors misrepresentation.
Yes.
They told me I couldn't lose.
Yes.
But the question that arises then in that context is, as a matter of causation and foreseeability and what have you, could you tack on these losses in respect of other projects? Say the very matter that the Deputy Chief Justice didn't need to grapple with because he said, well, you're too late, you should have raised this long ago.
Well, the causation case, the new causation case, is in the particulars of claim bundle 1, tab 5,
Yeah.
page 53 onwards. I quite take it that the Deputy Chief Justice did not in the first proceedings grapple with the question of whether those losses would have been recoverable under the various claims and made. But he could have, given that this was the claim made was a no transaction case, and that the case, the case has always been that, well, the claimant's case is that these real estate losses could have been claimed in the first proceedings because they tried to bring them in. So they obviously took the position that they could claim those losses because they actually tried to claim part of the real estate losses in the first action and were refused because they were too late. And which is an acknowledgement by them, I suggest, that the claims could have been because they actually tried to claim it, because their case has always been, right from the first letter before action, that this is a no transaction case, and we are claiming all losses suffered and suffered from investing in the case. And these include at least these tower losses.
Well, do you submit that we don't need to grapple with any difference that may arise between a claim put in deceit on the one hand and a claim put for negligent misrepresentation or mis-selling on the other, albeit fraudulent mis-selling?
Well, there could be this point, Miles, that if you are considering whether to plead the deceit claim in the first action, you have to look at whether the pleading of that claim opens up an investigation of a whole new causation within the action. Now, in my submission, certainly not such as would have prevented them bringing it into that action, and certainly not such if you had acted responsibly and the real estate losses were already part of the proceedings. But I don't think your logic needs to deal definitively with the question of could they have been pleaded under this original cause of action. They could have been pleaded because it was a no transaction case, and the whole case is that this was caused by the investment in the loan. So yes, it could have been pleaded. Yes, they've recognised that by trying to plead them later on, tried to have them.
You say good, bad, or indifferent in terms of causation and what have you.
Well,
that's not the point. The point is it couldn't have been done earlier and they failed to do it then, and it's even later now.
They may have failed. They haven't got their claims. They may have failed. We may have put any number of arguments against them. We may have failed. But certainly, on the question of the could and should question, the proof of that possible is the fact that they actually tried. But they were too late, and that the fault of being too late was theirs. And that's why they got stuck in it. I'm going to move, 5 minutes remain. Would you wish me to start on Aldi, or would you like to do that at 1:55, or
whatever you find most convenient from your perspective?
Perhaps I'll just deal with the introduction, just so Aldi is firmly in our minds. The grounds 1 and 2 relate to the Aldi guidelines, and the claimant's failure to raise with the new deceit claim in the 2009 proceedings, either with the defendants or with the court, or to try to amend their pleadings. Now, the Aldi guidelines and the treatment by the judge obviously forms the basis of grounds 1 and 2. And with that, I ought to perhaps go directly to what Aldi says.
in the authorities bundle 1 tab 13.
Yeah.
And one has the oft-quoted passage. Well, the head note was cited by the judge, but the oft-quoted passage is paragraphs 30 to 31, page 206 of the bundle. And perhaps I should read this because it is quite significantly. One really reads the 29, 30, and 31, just starting from 30. Parties are sometimes faced with the issue of wishing to pursue other proceedings, whilst reserving the right to existing proceedings. Often no problem arises. In this case, RDW has been asked not each, in truth, near at one time between August 2003 and the settlement of the original action, but there was a potential problem that was never raised with the court. I've already expressed the view that it should have. The court would, at the very least, have been able to express its view as to the proper use of its resources and on the efficient and economical conduct of the litigation. It may have seen if a way could have been found to determine the issues applicable to Aldi in a manner proportionate to the size of his claim and without the very large expenditure that would have been necessary if Aldi had participated in the trial of the action. It may be that the court would have said that it was for Aldi to elect whether it wished to pursue its claim in the proceedings, but if it did not, that would be the end of the matter. It might have inquired whether the action against excess underwriters could have been expedited. Whatever might have happened in this case is a matter of speculation. However, for the future, if a similar issue arises in complex commercial multi-party litigation, it must be referred to the court seized of the proceedings, plainly not in the interest of the parties, not only in the interest of the parties, but also in the public interest and the interest in efficient use of court resources that this is done. There can be no excuse for failure to do so in the future. And the way the judge addressed that, and I'll come to the importance of the guidelines as it's been expressed in subsequent Court of Appeal cases, several, in 5. The way the judge dealt with that, one sees in paragraphs 22 to 23 of the judgment. Where he says in 22, page 11, this is back in the core bundle, tab 1. This approach is entirely consistent. He's read the head note of Aldi above, with the overriding objective and the consequent expectation of parties to put their cards on the table. But there is some force in the reservation advanced by the claimants that failure to raise the matter with the court and enable the court to express its views on the efficient and just conduct of litigation would be of somewhat less weight in the DIFC court, where there is no reference to the decision or its implications in its rules as compared to CPR 3.4.2. He says 6, but I think that must be B, there is no 6. Now, as for the judge's stated reasons for saying somewhat less weight, just to get the first point out of the way, there is no difference between the RDC and the CPR. The rules are uniform, and CPR 3.4.2b equals RDC 4.16.2. It's exactly the same. The next and quick point to make is that the policy of the two sets of rules is obviously also aligned, because in the RDC, I think we do have these in the authorities bundle. I'll be given the reference because I've been using my separate copy of the rules here. Authorities bundle 2, tab 32. So, sorry, volume 1, tab, authorities bundle 1, tab 32. And if you look at RDC rules 1.6, you have the overriding objective, which, as is well known, includes saving expense, dealing with cases in ways which are proportionate,
ensuring that it's dealt with expeditiously and fairly, and allotting an appropriate share of the court's resources while taking into account the need to allot resources to other cases. You have 1.7. The courts must seek to give effect to the overriding objective when it exercises any power given to it by the rules. Now, the clause included power to strike out. So when you are proposing or asked to exercise a power to strike out, you have to have regard to the overriding objective. And then at 1.8, the parties are required to help the court to further the overriding objective. So the parties have got to help the court, including, you could say, well, they're all raising these issues with the court. And 1.9, the court is as a duty actively to case manage cases. Those are all exactly as they appear in the CPR. And so there is, in our submission, no difference in the policy of the two sets of rules. Well, that might be the difference.
Yes, thank you.
All rise.
Before the adjournment, I was addressing the Aldi guidelines point, and I'd made the point that the policy of the CPR and the RDC are on their face identical in relation to the overriding objective and the duty of the parties and the court to apply it, seek to apply it, including in relation to exercise of powers. The point is also that for this purpose we need the Treaty case and the first authorities bundle in tab 24, in case we looked at earlier on the hypothetical case management part. This the Treaty case, authorities 1 at tab 24. And I was going to go to bundle page 477. The English Court of Appeal of that case, picking up paragraph 48 through to 477, we have Lady Justice Arnold saying, if there's a view among commercial practitioners that the Alpen guidelines are subject to exceptions or optional, I remind them following this decision, if there's 5 decisions in this court, when the court has been asked to strike out proceedings because the Alpen guidelines are not followed, those who did not observe the practice cannot hereafter complain that they thought it was a practice to there are exceptions. In fact, the LD guidelines are not translated into a rule of procedure in the CPR or been made the subject for practice direction doesn't matter. So it's irrelevant that LD hasn't been translated into a rule of procedure in the CPR or by extension the RDC or made a specific practice direction. While we're in the authorities bundle, if we could go to an earlier tab 14, which is Stewart and Goldberg, one of the earlier Court of Appeal cases on Aldi. On tab 14, I just wanted to show you what is said by Sir Anthony Clark, Master of the Rolls, at paragraph 97, which is on page 236, where he points out that this is not a new consideration, 97, page 236. He says, well, these considerations have been highlighted in Aldi, they have relevant considerations at least since the CPR came into force in 1999. So these are not new considerations as far as the court is concerned. And the final point on that, while we're in the authorities bundle, I'm afraid it's back to Treaty tab 24, where Lady Justice Alpen says, before it showed me, I should have gone to this before, it's page 477 of the bundle, paragraph 47. She says, in my judgment, when Lord Justice Thomas held at the end of the passage set out above that there could be no excuse, he meant there were no exception.
it would not be open afterwards to a party to claim that it was not bound to seek management directions about a proposal not to join a party against which it might subsequently allege liability arising out of substantially the same facts. This appears to be the way in which this phrase has been interpreted in the four decisions of this court summarised above. So no excuses, no things, no exceptions, and that's the way that the Court of Appeal has been interpreting it. In our submission, reverting to the judge's treatment in this case of Aldi, there does not appear to be any justification in our submission for watering down Aldi in the DIFC, which in my submission is what the judge has done. The policy on the face of the rules is identical. And for this court to distance itself from Aldi on what I would suggest is an unprincipled basis would be regrettable. The DIFC can, of course, depart from English procedural approaches, but when it does so, I would suggest it does so identifying the rationale and perhaps local conditions that call for a different approach and so on, and I'm sure the panel will be aware that RDC 2.103 provides that the court, insofar as the rules or the guides make provision, the court may adopt the CPR with such changes as it considers appropriate. It is a relatively young jurisdiction, and a lot of questions of substantive law and procedure are going to come up in the DIFC for the first time. But of course, the court declares what the law is and has been, and it would be, in my submission, unorthodox to let a party off the hook simply because it's the first time that Aldi has come up in a DIFC court, especially when you have a party that has a sophisticated legal team and well knows that the RDC and the CPR are the same and the authorities that apply under the CPR. And if it doesn't matter that Aldi hasn't been translated into a rule or a practice direction, in my submission it can't matter that the RDC doesn't have commentary in its rules commenting on Aldi and the subsequent authorities. And there's another criticism we have, a related criticism, is that the judge didn't explain what he meant by Aldi Light in his judgment. So you have this rather unsatisfactory position where you have a confusing middle ground, where he has said Aldi maybe of somewhat less weight in the DIFC. The failure to raise the matter maybe of somewhat less weight. So we have a rather confusing middle ground, which may cause difficulties in cases going forward. But the short point is that we say that Aldi ought to be applied with its full vigour in the DIFC. It's important there's no confusion about it. There are very important public policy reasons why it should be. And we would suggest that the court should make it clear that the judge was wrong, as a matter of principle in this case, to water down the application of Aldi in the DIFC. That's really ground one. Ground two, my lords and ladies, really about the application, how he then applies Aldi to the facts of the case that were before him. Because he says, if one looks over the page 12 of the bundle, paragraph 23, he describes it as, in 23b, merely a factor. He says, however, a breach of the Aldi guidelines is merely a factor in broad merits-based judgment, albeit pertinent to supporting a conclusion of abuse. And then, of course, he finds, dropping down the page at 25, sorry, I beg your pardon, not 25, 30, it's 2 pages on at 31, he says, so it's page 14 of the bundle at 31, he says, 4 to 5 lines in, the crucial question that arises is what order, given the eventual objections to the bank, court would have made of the application. So, to elevate the hypothetical CMC to being the crucial question, the problem with that is that it downplays the significance of the failure to comply with the Aldi guidelines. And two things get lost in that process.
It is true, and I think we went to this earlier, that Crete says a breach of the guidelines does not automatically mean a strikeout. It's clear about that, and you can assess the seriousness of the breach by looking at, if you can, at what might have happened if the CMC had been convened. But the two things that get lost are, first of all, if all you're concerned about is the outcome of the hypothetical CMC, and to the extent to which that might or might not prejudice the defendant, you completely ignore the fact that there is an important public and court interest in the application of Alpen, which is in play here. Because there is a vice in and of itself in the court being deprived of the opportunity to manage the litigation in an efficient and economic way, with regard to the use of its own resources, the interests of other litigants, saving time and expense, and a public interest in ensuring, so there's therefore a public interest in ensuring that ALDI is applied in all cases, no exceptions. So with regard to a breach of the guidelines, that's in and of itself is an important factor. And just, if I could just show you the authorities, a couple of the ways the judges have articulated that. Back in Authorities 1, Bundle 1, if I go to Gladman, which is one of the other Court of Appeal decisions we haven't gone to yet, it's one of the other 5, one of the 5. Authorities 1 at tab 16. And I was going to go to what Lord Justice Briggs, as the other was, said at paragraph 64 to 65, which you find on bundle page 305. And he says this: by contrast, case is referring to Lord Justice Thomas in Alpen. Observations about avoiding these difficulties by prompt application of proactive case management were directed mainly at the future rather than the past. He plainly regarded the requirement and to refer a contemplated future claim of the case management directions in the earlier claim as mandatory and was serving the public interest in the efficient use of court resources. He described a failure to do so as an excusable. Furthermore, in the Stewart case, Lord Justice Sedley interpreted Clark, Master Barol, spelt out in express terms that the failure to follow the LD guidelines involved the claimant running a risk that the pursuit of the second claim would constitute abuse. As has been repeatedly said, the conduct of civil proceedings is a process in which the stakeholders include not merely the parties, but also other litigants waiting for their cases to be tried, and the public at large who have an interest in the efficient and economic conduct of litigation. I consider that Mr. Justice Arnold was correct to treat a failure by the appellant to follow guidelines laid down as mandatory future conduct in 2 successive reported decisions of this court as relevant matters pointing to the conclusion that the second claim constituted an abuse of the process of civil litigation. There are other authorities I can go to, but I think it's pretty clear from Lord Justice Briggs, now Lord Briggs, when he said in Gladman that is a factor that gets lost if you treat the hypothetical CMC as the crucial question, and it was left out of account, therefore, that factor by the judge. Now, the second thing that gets lost if you just treat consideration gets lost if you treat the hypothetical CMC as the crucial question is that it will not be appropriate as a matter of general approach to elevate the hypothetical CMC to being the crucial question, because in very many cases the court may be unable to say with any degree of confidence exactly what would have happened at the hypothetical CMC, because case management comes in all sorts of shapes and sizes. It's a creative process. Different judges may come up with different solutions. It depends on unknown factors like the state of the lists, the availability of witnesses, of fact, experts, counsel, the court, and so on. Now, it may occasionally be the case that that you have a clear and obvious case as to what would have happened in a hypothetical CMC. I mean, Barrow and Bankside, an authority which is actually referred to in the judgment, is an example. I won't go to it. It's an authorities bundle at 2 and 36. But that was for example, that was where you had Lloyd's test case litigation, and certain issues were being tried generic issues were being tried in test cases, and later on, one of the test case plaintiffs wants to bring another claim that wasn't one of the generic issues. And it's easy to see why in that sort of case it's clear and obvious that the claimant wouldn't have been able to bring it in the earlier proceedings, because that was a test case procedure only for certain generic issues and things weren't hit. So it's somewhat mystifying that the judge, in his judgment of paragraph 32, seemed to find some support from the Barrow and Bankside decision in what he was going to do, because the cases are light years apart. In the case before the judge, the sheer number of variables of the timing of the CMC, the subject matter, the prevailing circumstances, there were so many variables that it really was not a Barrow and Bankside type case. And in our case, it made the hypothetical CMC a more difficult exercise. So it was for that reason somewhat dangerous to elevate it to the crucial question, simply because there are so many moving parts involved in that assessment. Now,
in the present case, I assume it was simply that time ran out. Quantum wasn't dealt with. The point is made in a number of places that a split trial wasn't ordered, but in practice,
in practice, a number
there was
of
a liability trial, and presumably no evidence on quantum was heard at all at that stage.
I think that may be right. That may be right, Mal. There are obviously a number. They ended up, in effect, having a quantum.
Well, I realise that, but
Yes.
I was inquiring as to why that was.
I think my understanding, I wasn't there at the time, Mal, but I think, and I'll certainly check, but I think my understanding is that they ran out effectively around at the time. I think it may even have been agreed at some point to put these issues further. There was an agreement between counsel and announced to the court in the opening of the trial, as I understand it. So quantum issues ended up de facto being deferred, even though there was no split trial ordered. Well, it's relevant also to this, Michael.
It's highly relevant, isn't it? Even if there was an application in April 2013.
Yeah. Well, quite, because you ended up having two trials anyway. Effectively, de facto, you had two trials, and of course, one of the cases.
That was a month before the hearing began.
Yes.
By which time counsel would, if they applied their minds, and bearing in mind, Latif's comment that it's always the last minute when anybody really gets to grips with it. But about that stage, they might then have realised they weren't going to get quantum in the however many weeks have been made available.
And might sensibly have suggested a split trial rather at that point, rather than just at their openings, which they effectively did. And the reason I mention that is that one of our criticisms of the judge is that even if you put the hypothetical case management conference as late as he does, which is April 2013, there are still much better case management solutions than this rather binary model that he uses, because you could, of course, have split the trial at that point. And that's effectively what happened a month later, is you got a split trial. And so the idea that the court would just have thrown up its hands and said, you have to have a separate action, an entirely separate process for these claims, is just not realistic. Even a month away from trial, I would suggest. And in fact, we've sort of come on quite conveniently to the next ground, which is ground A, which is the judge's view of the hypothetical CMC and what would have happened. Because, so let me just address ground A. The principal criticism of ground A, and you have the point, is that it puts the CMC too late. It puts it in April 2013. It should have been latest middle of 2012. And the judge therefore got the timing wrong, which rather undermines his reasoning in relation to the hypothetical CMC. And if, of course, the CMC is happening a year out from trial, you have a vast array of possibilities as to how you case manage these cases together, and you would have little difficulty in adding the new claim, even if the real estate losses haven't been brought in at that point. You've still got time to meet a May trial in 2013 by having amendments to the pleadings, disclosure, any additional disclosure, and in line for a trial a year later.
Was the trial date fixed by the middle of August 2012?
It was fixed. We've got, the judge said, slightly erroneously, I think, and possibly misled by counsel at the time, he said in his judgment it was fixed in April 2012. We found the CMC order, which on the 27th of May 2012 says the trial is to be fixed. And I think it was fixed shortly thereafter. So it looks like it was fixed in about late May 2012, the trial date. But of course, we're envisaging having a CMC probably very shortly after the trial date's been fixed. It's only been fixed for a month or two. By the time we say at the very latest, the claimants should have been bringing, in the Aldi sense, should have been bringing their new claim before the court to case manage it and give the court the opportunity to decide how best to deal with it, not to decide for themselves to hold it back. And the judge himself said on the transcript below, we can go to it if you like, it's in bundle 11, but he observed, talking about a CMC in about September 2012, he said, well, there'll be all sorts of possibilities. That's what the judge himself said on the transcript. I mean, for your note, that's bundle 11 at tab 117, page 5564 and 5566. So that's our principal position on the hypothetical CMC. But even if the judge was right to take a CMC as late as April 2013, we say that his approach was still wrong because there were at least two very viable case management solutions, which would have been vastly preferable to the rather toxic predicament that my client now finds itself in. One would be to direct a split trial at that point, and which is what actually effectively happened a short time thereafter. And you have a first trial of liability issues in May 2013, maybe a small slippage if additional amendments to the pleadings had to be made, but you're essentially dealing with another fraudulent misrepresentation within conversations that are already in the witness stage, in respect of which the disclosure is supposed to have already taken place. And you could have included issues of authority, which were all common to the existing claims. There was Swiss law evidence on that, Kuwaiti law evidence on authority. It all been prepared for those other pleadings that I had shown you earlier about authority. And there might have been some debate about whether you included scope of duty issues. Do you include any of the causation issues? Can any of those be taken first up? There could have been some debate about that. But the liability issues could and should have, they belong together as part of the same factual run. These conversations were already part of the facts relating to the 2009 proceedings, and they should have been decided on by one judge at one trial. Same witnesses of fact, same legal teams, same experts on Swiss law and Kuwaiti law and authority and attribution. And had that been done, there would, in my submission, been huge costs and time saving and efficiencies to be had over having two completely separate trials, and the second defendant now having to face the prospect of reconvening in the future for a second trial on issues of liability. And your second trial, if you split the trial, the second trial addresses issues of quantum, which is what in fact happened anyway, and you would thereby allow time for disclosure on the real estate losses and so forth, even if they had not been brought forward by that time, and in fact they should already have been brought forward by that time anyway, as we discussed before the mentioned adjournment. So the points made against us, as far as I can ascertain from what was said below on the permission here, are that it said, your case management options have problems. It's first said, well, you'd have lost your fixture anyway. Well, I think that's debatable, but I could see how one could still potentially make a May trial for liability issues. But if there had been some slippage, it wouldn't have been a huge slippage in time to bring the deceit into part of the liability trial. There may have been a little bit of slippage, but I don't think it's a given that we've necessarily lost the day. And then it said against us that it would result in a heavier and lengthier second trial on quantum. Well, that is true if you bring in the real estate losses. But even if they are excused for not bringing those in earlier, but it would still have been more efficient and effective and economical to try that quantum case together with the quantum case that was tried, not just because you don't have a duplication and the obvious extra cost of having two trials rather than one, but because there was actually a huge overlap in causation type issues, because there were quite a number of causation issues in the first action, which turned, for example, on the wealth of the claimants, issues about whether they had sufficient funds to meet the margin call, and were they at fault for not using those funds to meet the margin call when it actually came in the end? Did they cause their own loss as a result of that? There were issues about whether the claimants caused their own loss by refusing to pay off the AVK loan, and so forth. And there are obviously a huge overlap between that and the causation case in the 2016 proceedings, where the claimant is saying, but for this 10 million, I would have lost $1 billion, because I couldn't service my AVK loans, property lending. So the claimant's wealth and ability to service other obligations would have been at the centre of both causation cases, and there would have been a huge time and convenience of having those tried together. Yes, it would have been longer than causation actually was, but as nothing in terms of cost and inconvenience compared to the situation we currently find ourselves in. So that's the first option, would have been a split trial, even in April 2013. The second option would actually be to adjourn the trial. And the judge said that that would not have been acceded to. And he, at paragraph 32 of his judgment, and he refers to some procedural developments in relation to that, the fact that the trial had been fixed for about a year, less than a year, but about that, and the fact that witness statements had just been exchanged and so forth. But in my submission, the judge's confidence about that is entirely misplaced, because if an adjournment had been necessary in the interest of justice, a judge would have adjourned that fixture. And if an adjournment had been necessary to avoid duplication of proceedings and having an entirely separate and duplicative action at trial, there's a very good chance that a judge would have acceded to that. And there would have been very powerful reasons for that as to why a judge at a CMC would have done his or her utmost to avoid duplication of proceedings, and which the judge in our case below has ignored. Because first of all, having duplicative trials between the same claimant and same defendant offends every aspect of the policy behind the Henderson and Henderson principle. You have a lack of finality in litigation. You have the same defendant being vexed twice in the same cause, which is a classic abusive situation in Henderson and Henderson. You have the uneconomic use of court resources, having to have two trials rather than one, and you have the huge increase in time and costs to both of the parties. So it offends, having a duplicative trial offends pretty much everything that Henderson and Henderson is about. So the judge would, in my submission, have been striving to do his or her utmost to avoid a duplication of trials. And furthermore, the judge would have had in mind the prejudice or potential prejudice to the defendants that they would suffer if there had to be two separate proceedings, and which we are now actually facing. The judge was dismissive about prejudice,
to the defendants. He was dismissive in paragraph 36 of his judgment. He said something rather extraordinary, and this means, conveniently, I could move on to ground 10, which is the fact the judge said there's no prejudice to my clients, which is just wrong. And he said in paragraph 36, starting 6 lines in, but standing back from the detailed arguments, I'm unable to accept that the 2016 proceedings amount to unjust harassment. The outcome is the need for a separate trial, which is what would have happened in any event. It imposes no material, let alone prejudicial burden. That finding is wrong because it leaves out of account, impermissibly leaves out of account, the prejudice and potential prejudice to my clients, which is another complaint we have about the judgment. And the potential prejudice comes in a number of forms, which I will just run through briefly, if I may. First of all, I've mentioned already the increased costs and delay and inconvenience to the defendants and its witnesses and the lack of finality of having 2 separate trials, which is real prejudice. Below, I note that some reliance was placed by the claimants in this regard in something said in the treaty decision, which perhaps you go back to at this point, back in Authorities Bundle 1 at 24. There was some reliance placed by the claimants on something that Lady Justice Arden said at paragraph 53 of the treaty, which is on page 478 of the bundle. And when one gets there, 53, she says this: for the same reason, the judge is bound to consider the measure of the prejudice suffered by tribunal. It was one of the relevant circumstances, but Mr. Malik is unable to point to any very specific examples of prejudice. The party needs to show more than the generalised prejudice to obtain a strikeout. Now, I think it's that sentence that is relied on. Now, the Treaty was not a case of suing the same defendant a second time. A treaty was a case where the complainant had never been sued before, but said that they should have been included in a previous action. So, of course, Mr. Malik was not able to put forward the prejudice of having to incur the costs and inconvenience of a second trial, because they'd never had a first trial, never been involved in a first trial. But, of course, the fact that there is duplication in our case of costs, and we're being vexed twice in the same cause, is a real item of actual prejudice. It's not generalised prejudice, it's real and it's actual, and my client having to sign checks for the bills will know that. Indeed, it's actually part of the important policy considerations behind the Henderson jurisdiction to avoid this very kind of prejudice. So that's the first head of prejudice. The second head of prejudice, or potential prejudice, is the issue of estoppels from the 2009 proceedings, because the judge refers to the issue of estoppel argument earlier in his judgment, but he does not address our arguments on it and leaves them out of account. So it's another instance of the current judge leaving a highly material factor out of his consideration. And if one goes to the 2016 proceedings, for the particulars of claim, one can see what estoppels, a whole raft of estoppels are alleged against us. And that's back in Bundle 1, Tab 5. Particulars of claim. The issue of estoppels alleged, importantly, they include not only that the statement was made, but also that it was made within the scope of Mr. Wally's authority. If I can show you the pleading, with the pleading of the issue Stopples, please. It's tab 5 at 32. And at 50, paragraph 51, the claimants say this: in the liability judgment, the court made a number of factual findings which provide part of the factual background of these proceedings. Those findings are raised to the cartel, thus binding between the parties in these proceedings, and are referred to as appropriate below. And what you get is a number of paragraphs which have references to the liability judgment, to paragraphs of the liability judgment, saying that these are res judicata, and those include at paragraph 66 over at page 36 the statement itself in paragraph 66, and the references to the liability judgment are there given. So they're saying the statement itself is res judicata, and we asked them to clarify the position about authority. And I showed you earlier what they said about that in their response to the RFI, where they said there's an issue of estoppel on authority too. And that's in behind tab 7 of the same bundle at page 93, where the passage I showed you, quote 4, where at 26 and through to page 93 behind tab 7, it is said in the third line, the manner in which the ostensible authority arose is res judicata between the claimants and the second defendants, and that is a reference to passages in the liability judgment. So they are effectively saying that they're 90% there of liability on this $1 billion claim. Now, the court, in my submission, also has to look at the circumstances in which, if they apply, these issue estoppels have been obtained. They have been obtained at a trial where the statement was not, well, it wasn't centre stage in the way it is now in the 2016 proceedings. You can have a debate, and obviously there will be a debate about how significant the statement was. But I showed you before lunch that the claimants are saying these were fundamental, essential parts of the judge's findings, so they give rise to issue estoppel. So, i.e., they were significant and important parts of the proceeding. But one can debate how significant they were. But what is clear is that the August statement was not centre stage in the 2009 proceedings as the fulcrum of a $1 billion claim, fraud claim, as it now is. It certainly wasn't that, whatever view one takes of its relative importance. But one knows from what's been said below that the claimants and the pleading I just looked at, that the claimants will be contending very strongly that there's an issue estoppel on the statement and other matters. And if I could just direct you to another passage in the submissions of Mr. Fraser for the claimants below about what he said about issue estoppels. It's in bundle 11 and tab 117. This is part of the transcript below.
Sorry, tab 111.
Tab 117, mate.
117.
117. And this is part of Mr. Fraser of the claimant's submission. And he says at line 17, page 5460, 5460.
Page 5?
5460. Mr. Fraser at line 17 of that page says, this still leads to my submission model that faced with all of this, it does seem very difficult for my own friend to sustain this submission that no issue of estoppel will or can possibly arise in these proceedings concerning the dishonest statement. That somehow this is unfair, that it should. And you've seen the pleading itself. They are pleading and will argue hard for issue estoppels.
in the current action. Now, as to how those issue estoppels will have been obtained if they apply, the circumstances of the first action, well, the August statement was not even in the list of issues for the first action, which gives you an idea of its relative importance for these purposes. The list of issues is in bundle 3 behind tab 48. If my ladies and my lords wish to look at it, I'm really referring to it to make a negative point, that that's the list of issues agreed for the trial, and it wasn't there. And Mr., as I mentioned before, Mr. Brindle, for the first defendant, not for my part, but for the first defendant, conducted some cross-examination on the question of the statement. I mean, you may find it interesting just to look at that. It's very short, it's 2 pages. And it's the transcript of that cross-examination is in bundle 5 at tab 64. I'm not going to read all of this, and it would take perhaps unnecessary to do so, but the nub of it is at pages 2255 to 2256, is the nub of the cross-examination on it, where from line 2255, line 7, Mr. Brindle says, keep your witness statement going back 264 of Alia. He made it clear to you in mid-August, one way or another, wherever it was, that there was a collateral shortfall in your mother's account. Did he not? That was never mentioned to me by Mr. Alia. Instead, there's an interpreter in between you. He told you that needed to be covered by a payment of 10 million. And there's an answer to the issue of the 10 million is not about my mother's account, etc. Mr. Khorafi gives his answer. There's a little bit more questioning over the page, top of page 2256, and Mr. Brindle, it's line 6. I have to suggest to you, Mr. Khorafi, that's wrong, isn't it? This 10 million was paid by you because there was a collateral shortfall, and this was paid as collateral, and so that's completely incorrect. And then they move on at line 22. Now, so you get a very short cross-examination by the first defendant, so short that when he came to his liability judgment, Justice Chadwick couldn't recall any cross-examination and recorded that Mr. Khorafi's evidence had gone unchallenged on this point. That you will find, it is important to look at, I'm afraid, in bundle 8 behind tab 75. This is the liability judgment. And tab 75, bundle 8, and the relevant part of the judgment is paragraph 210, which is at page 3955. This is where, this is the judgment in which Deputy Chief Justice Chadwick accepts Mr. Khorafi's evidence on those events. And he says in paragraph 210, page 3955, he quotes Mr. Khorafi's witness statement on telephone calls in August 2007, and he says, but beside the second hole punch, that evidence was not challenged in cross-examination. So it's so brief that he has no recollection, the trial judge has no recollection of it.
Obviously, it was not a headline part of the cross-examination, if I can put it that way. As I mentioned before, my client, the second defendant, through Mr. Black, conducted a no cross-examination of it and didn't challenge Mr. Al-Kharafi's witness statement on this. There were other witnesses who would have had relevant evidence to give. Mr. Taha, for example, he gave evidence at trial. That was Mr. Waller's accountant. And you remember there's an allegation in the defence that says he was told about the margin shortfall on the 15th of August in the telephone conversation, and he wasn't cross-examined on it either. You can see he deals with Mr. Taha's evidence was dealt with in the previous case, 4. But he wasn't challenged about his evidence that there was no mention of a margin call. What one can say with some confidence is that if $1 billion had potentially been riding on this, whether or not this statement was made, you can be pretty sure that these witnesses would have been cross-examined uphill and down dale on it, and that the defendants would have torn up the floorboards to try and find some evidence that casts doubt on their credibility in the account. But as it is, that did not happen. And the cross-examination should have been much more thorough and effective. I'm not criticising those involved at the time. They had to deal with what was in front of them. But the result was that there is, as far as the second defendant submissions are concerned, there is one single sub-paragraph in their opening submissions that refers to this, and nothing at all in the second defendant's closing submissions. Now, the claimants say issue estoppel is not relevant to the current inquiry because whether or not there's an issue estoppel can be determined in the new proceedings by the judge in the new proceedings. So let's not bother about issue estoppel right now. Now, there are a number of problems about trying to sidestep issue estoppel like that. The first is that the risk that we may be subject to issue estoppel on 90% of liability issues on a $1 billion fraud claim is itself viciously prejudicial to my clients. Obviously, there is going to be a very real issue about this in the 2016 proceedings. The parties have opposing views on it, and no doubt that will be hard fought in front of the judge and probably Court of Appeal as well. And there's also a risk, paradoxically, that the claimants will say we're barred under Henderson and Henderson principles from relitigating these points on a could and should basis. So it's viciously prejudicial. There is reliance is placed by the claimants on Arnold and Westminster Bank to suggest, I think, effectively. That's in Authority Volume 2 at 42. I think to suggest that, well, if there's a problem with these issues, estoppels, the trial of the judge will say you can't rely on them. Well, that's not what Arnold and Westminster says. Arnold and Westminster said that there was an exception to issue estoppel, or potential exception, if you came up with further material that you could not with reasonable diligence have adduced the first time around. That would potentially be an exception to issue estoppel. Also, a change in the law might be potentially an exception. But it's silent as to the other circumstances that might prevent a party relying on issue estoppel. And it certainly does not endorse any general principle that you can't rely on issue estoppel if it's unfair, and what unfairness might mean. So it gives us, for present purposes, no comfort at all on the question of whether issue estoppels will be applied in this case. Because, well, for a number of reasons, but partly because in a substantial part, that argument will turn on a debate about how central the findings were to the case and to the judge's reasoning in the case. And that's, of course, something that's open to argument.
One asks rhetorically, will the court in the 2016 proceedings, if they go ahead, consider what we say are the unfair circumstances in which these issue topples may have been obtained? Will they take that into account? The answer is one just does not know whether they will or whether they won't. It's entirely unpredictable. So that's the issue topples are the further head of prejudice. And there's yet a further head of prejudice, which is the dry, what we on this side call the dry run point. And it's a vice that the courts have been concerned about. And the vice I'm describing is a party having a dry run at cross-examination and witness evidence and submissions in one context, and then using that to found later different claim. Because that can potentially present a party with a huge tactical advantage. You have a dry run where you test the waters out, your own witnesses, the other side's witnesses, how the submissions go down, how the evidence is received, and you may extract some useful comments in the judgment or even findings, and then you use that on a future occasion. And what's more, in our case, that's done at a time when there was no claim based on the statement. It was a more peripheral statement, and the damages claim was much, much, much smaller. And I'll just show you what's said in two cases about that type of conduct. And if we can go, I think Clutterbuck might be a good place to go first. The authority is number 1 at 23. Clutterbuck is I think, possibly one of the 5 we haven't referred to yet. The English Court of Appeal. It's behind tab 23, authority number 1. In terms of the facts in Clutterbuck, they're a little bit involved, but essentially there was wrongdoing alleged in relation to 3 joint venture agreements. And in action 1, the claimant sued on 2 of the joint venture agreements against the co-venturer and failed. But in action 2, the claimant sued on a 3rd joint venture agreement against a different defendant. And it was held that pursuing the original 2, even against a different defendant, would be abusive. So he couldn't pursue the original 2 joint venture agreements, but he could pursue the 3rd. But the court was nevertheless troubled by the dry run that the claimant would have had at the witness's concern, and expressed that at paragraphs 104 and 105 of the judgment. It's page 600, it's 468 in the bundle. So paragraphs 104, 105, page 468. And Lord Justice Kitchen it says this. What then are the other matters to which the Deputy Judge had regard? I'm conscious that Mr. McCormick, Mr. Gonzalez, and Mr. Pixton were cross-examined in the Alamedians, the first action, about the Cleveland Place project. That's the joint venture in the second action. I'm also conscious that Mr. McCormick was cross-examined by reference to the final documents, which is little known notice, and that Mr. Cakebrow's counsel, the claimant, sought to suggest that Mr. Nichol had been dishonest in his dealings with regard to Cleveland Place. I also accepted Mr. Gonzalez's professional integrity and competence were viciously questioned. It was these, among other matters, which led the Deputy Judge to observe that it was hard to resist the conclusion that the claimants had used the Alamedi litigation as an opportunity to conduct a trial one of their claims against Mr. Nichol. I have to say I found this a troubling aspect of this part of the appeal, as the Deputy Judge observed that Gilbert, Stewart and Goldberg deprecated this type of behaviour. On the other hand, Aspert has made no findings in relation to the Cleveland claim, and so there's no risk of inconsistent conclusions whether the Deputy Judge accepted the treatment of Mr. McCormick, Mr. Misselbrook, and Mr. Gonzalez was a long way in the treatment of one of the key witnesses in the Gladman case. Now,
that's a little different, isn't it? Because they were using it intentionally, as suspected for that purpose.
Well, one doesn't know. We've not had a waiver of privilege in this case, so one isn't able to fully investigate the question of whether the holding back in this case was tactical or was a mess up, a mistake. Whether it's one, it's obviously more grievous if it's deliberate, but it's nevertheless causes prejudice, even if it's not deliberate. It causes prejudice to my clients. Your Lordship is right to say, well, the thrust of the criticism, the sting of the criticism, is worse if it's deliberate, what has gone on. The way, there is a sense in which our situation is worse, because not only have you got the dry line cross-examination, which has gone on, but you've actually got findings made, which they're trying to use against us. So it's gone one stage further. And it may not be necessary to go there, but there were similar comments made with Stuart Goldberg, the judge here alludes to them, by Sir Anthony Clark amongst the rules. And I think, actually, since it's in the same model, we could just look at this quickly. It's tab 14 of the same model. Stuart Goldberg looked at this case before. But for this purpose, it's to go to 97, the end of 97. I'll just read these conclusions. He said in the last few lines of the letter H. The reasons I give, the reasonable cause is raised in the matter of the first offence to the judge, rather than to make a tactical decision to keep his powder dry until he saw the cross-examination of Mr. Lindy went. I fully accept that if the inference was that this was tactical, it's worse, but it's prejudicial even if it's as a result of a mistake. Now, the judge in this regard was completely dismissive about the idea that in different circumstances there might have been a different outcome on the key issues. And this is actually our part of our complaint on round 11. And he says, what he said, just to remind ourselves, is back in the judgment, paragraph 35. He says in 35, the complaint is made by the bank that we would have cross-examined Claimants' witnesses differently if the deceit allegation had been raised. This is somewhat obscure given the challenge to Mr. Khorafi's evidence that he was not told by Mr. Alia that the 10 million reflected the collateral shortfall, the contrary expressed by the judge, and the judgment was mistaken. The difficulty facing the bank is that the judge found Mr. Alia to be a evasive witness with no real interest in assisting the court, a conclusion which the court of appeal found to be fully justified. The sentence on the previous page about the challenge to Mr. Khorafi's evidence, it's puzzling. It seems to refer to the 2 pages of cross-examination of Mr. Brindle, i.e. by another party. Part of the complaint we have, of course, is that we'd have cross-examined much more thoroughly if $1 billion had been writing and the evidence gathering exercise would have been exponentially more thorough. Secondly, the judge over the page, on top of page 16, he says Mr. Alia was found to be an evasive witness. Well, with respect to the judge, that's an unsatisfactory approach, particularly in a claim for $1 billion, to say Mr. Alia was a liar, that's an end of it. Particularly because Mr. Alia was not the only witness with relevant evidence to give about these events. He was a key witness, of course, but if you just look at what the Deputy Chief Justice said about Mr. Alia, in his liability judgment, that's back in, I'm afraid for that we have to go back to Bundle 8 and tab 75. Bundle 8 and tab 75. going to, when we get to tab 75, I was going to do the page 3930. 3930. So he's talking about Mr. Khorafi at paragraph 162, whose evidence on these events was believed by the judge. And he says that this, Mr. Khorafi, was the principal witness in support of the claimant's case. His evidence was given to an interpreter who was quite properly subject to search and cross-examination. It would be fair to say that Mr. Khorafi's recollection of events which had occurred some 5 or 6 years earlier was in some respects incomplete or unreliable as to detail, but I'm satisfied he was an honest witness who was making his best to assist the court. So in some respects incomplete or unreliable as to detail are found to be generally honest. And as to Mr. Taha, who also would have had relevant evidence, did have relevant evidence to give, over the page at page 3931, paragraph 165, the judge says this, Deputy Justice Chadwick says this, Mr. Taha gave his evidence by video link to the interpreter. It's fair to say that he was the least satisfactory of the witnesses called on behalf of the claimants, and that he was prone to be verbose, argumentative, and offensive in his answers to the questions put to him. Now, so the credibility issues were not all one way in this case, and the judge's approach just to say, well, Alia was found to be an evasive witness, really is far too broad brush, and it does not mean that Mr. Alia, in all circumstances, would always have been disbelieved on all issues. And it does not mean that the first claimants or Mr. Taha's evidence would always have been accepted on all issues. So just because you're a poor witness does not necessarily mean that you will be disbelieved on everything that you say. So that's brings me to the end of that ground. The grounds, I think I've only got two left. I need to say a little bit about the funding of the new claims, which the judge touches on, although it's really a make-weight point. And then I have to finish on ground 13, which is that the judge held against us the fact that we didn't apply earlier to strike the claim out. As to funding, this is something the judge touches on in paragraph 29. 29 and 30 of his judgment on page 14. This funding was put forward as another reason why Mr. Alia couldn't have added the deceit claim in the first action, lack of funds. And
sorry, did you say Mr. Alia?
I beg your pardon, I misspoke. Mr. Khorafi, first claim. I do beg your pardon. Now, first of all, it's apparent from Johnson and Gore Wood itself that lack of funds will not likely be considered an excuse for failing to raise in earlier proceedings an issue that should otherwise have been raised. Just to show you the court what Lord Bingham said in that case, it's in the Authorities Bundle 1 at 11.
That's in the extensive quote set out in Alpen, isn't it?
I expect it is. I'll perhaps I just read what is said behind this side. It's page 134 of the bundle in Johnson and Gore in the House of Lords in England, in internal page 131, where he says this by letter E, page 134 of the bundle. Thus, while I would accept that lack of funds would not ordinarily excuse a failure to raise an earlier proceedings an issue which could and should have been raised then, I would not regard it as necessarily irrelevant, particularly if it appears the lack of funds has been caused by the party against whom it sought to claim. So, not ordinarily excused, but not necessarily irrelevant. And the claimants in their skeleton below, back in the core of the appeal bundle, behind tab 5, in this respect, they refer to this as paragraph 32 of their skeleton, resisting permission, and this is page 74 of the bundle. and they say, perhaps rightly in this respect, they say the significance of this finding was limited about funding, and they're right to say that the significance is limited, and they also say correctly over the page that it was of limited relevance. They said, picking up on through page 74, that ECJ was justified in treating this aspect of the abuse inquiry as of limited relevance. And they're right to say that as well. Now, so we're dealing with a rather make-weight factor that was treated by the court as peripheral, and it would seem the claimants now agree that it's peripheral. But just to deal with it anyway, so it's, we've got it out of the way, and then perhaps if an afternoon break has to be taken, that might be a good point. The burden, although the persuasive burden to show abuse was certainly on my part, for sure, but this is an issue that the claimant raised on which they bore the evidential burden to prove that. They have said, yeah, I'm saying that we could not have funded this claim, and on that they undoubtedly bore the evidential burden. I always think the touchstone of these things is if you strike out the factual allegation, you lose it, and then you find out pretty clearly who's got the evidential burden. We then look at what the judge actually found in our litigation funding back in his judgment, to the extent he found anything at all, back at paragraphs 29 to 30 of the judgment. And the highest, really, he puts it, is that the last two lines of 29, he says, we said it would be inappropriate to attempt to resolve these issues. It would not be easy to meet them by the cost by realising non-liquid assets, notably in that context, resulted in HAT's litigation funding. And then he says he didn't think value would have funding in the next paragraph. No. So what the judge actually found was it would not be easy to meet the extra costs by realising non-liquid assets. And that's as far as he goes. He's not making a finding that they could not have raised the funds required. And in fact, he then goes on in 31 to consider the case on the basis they could have funded. So he obviously didn't regard it as a VAR, even though it was very negative to us in other respects. And we do have a complaint even about what he did say, because we say that he ignored evidence before him that the claimants had at least $72 million worth of assets. It's possible that his reference to it wouldn't be easy to meet them by realising non-liquid assets is a reference to those assets.
I'm sorry. Are you saying he found they could fund it, or are you saying he found they could not fund it?
Well, he seems to have been somewhat equivocal. He certainly doesn't find that they could not fund it. He seems to be just saying it wouldn't be easy. Now, the implication
but
of it not...
He says they couldn't get money from funders.
From Van.
Yes, from funders.
Sorry, he says that.
It's at 30.
Yes.
So 29, he said not easy to realise non-liquid assets.
Yes, I think
so
that
he seems to say it was difficult.
Well, that must be a reference to the claimant's assets.
Yes.
And he seems to be... He goes this far to saying it wouldn't be easy. That's as far as he goes. But that is not a finding that he couldn't do. It's a finding that it wouldn't be easy to do. So he's not saying, you have demonstrated to me you couldn't have done it. And in fact, the proposition that...
The history of the proceedings that we've seen certainly doesn't suggest that if $19 billion has been incurred, if not actually paid.
Well, that's the claim made against us. Some of that, I think, I was told at lunch and reminded was in a conditional fee uplift.
Yeah.
But it's still a huge number. It's still a huge number. And also, there is, and I should show you this, and I'm happy to take a break before we do so, because it may take a few minutes. There was evidence from the claimant's own side showing that they had $72 million of assets between them, and that Mr. Khorafi had a significant number of assets. It was adduced by the claimants themselves after trial because they wanted to resist a stay on my clients paying the money. They wanted to say, we're good for this, and if we have to repay it, we can repay it. We were all those assets. And here's our evidence through Ms. Hamdan. So there was evidence that they had $72 million of assets. The idea that you couldn't raise a few $100,000 of legal fees against $72 million of assets is, in my submission, quite fanciful. I mean, they may have been illegal, but you can always find ways of raising money against them. And we are talking about a balance of legal costs here above what's already being incurred.
This 72 million was a positive figure with no liabilities, or net of liabilities.
Well, it would have to. Well, if they were saying.
No, I'm sorry. Did they say that? You don't have to interpret it.
No. Well, I'll go to it. I think I'll go to it. And I'm happy to go. Well, perhaps I should go to it, so we're not under any misapprehension. And I'm happy to do that. I don't know if Roger was going to take a break.
Let's just do this.
We'll do this. It's Miss Hanlon's evidence, which in the 2009 proceedings, and it's in bundle 9 at tab 79.
Bundle 9.
Bundle 9. Now, this is a witness statement put in on behalf of all three claimants. You'll see, and it's November 2014, after trial, and she says she's a partner in Hamdan Shamsi for the claimants in this matter. And she's authorised, as she says in paragraph 2, by the first claimant through third claimants, collectively referred to as the claimants, to make this witness statement. And it's in response to an application for a stay of the paying the money, pending appeal. So they want to get the money from the original judgment without a stay, pending appeal, because they say we've got the wherewithal to pay it back if the appeal were to be successful. And in this, there's a subsequent statement that is perhaps even more specific, but in this statement, at 4235 of the envelope, 4235, paragraph 8, she says, 4335, she says at 8, the claimants are people of substance. Indeed, Deputy Justice Chadwick found that all were wealthy, which he cites the judgment, particularly the second defendant, becoming the second claimant, it's the mother, who inherited substantial wealth from her husband and family. The question for the court is whether the defendants are exposed to irremediable harm if they make payments in accordance with the order, given that in excess of $8.5 million of the sums payable are due to the second claimant. It's appropriate for the court to focus on her position primarily. She's the wealthiest of the three claimants, so has very substantial property assets in Kuwait. There's a reciprocal enforcement agreement between the UAE and Kuwait. The state of Kuwait has ratified 2 multilateral treaties in this regard, which refers to them. The defendants would have no issue enforcing any order made against the second claimant in Kuwait. First and third claimants, so that's Mr. Al-Khorafi and his wife, are also people of substance, as the judge found. There is no reason to assume they would not be able to meet any adverse order against them in the amounts of visits, i.e. $1.5 million for the first claimant, Mr. Al-Khorafi, and $0.5 million for the third claimant. In those circumstances, there is no risk of irremediable harm to the defendant. So they are saying they can pay those amounts.
Well, that's far cry from 72 million. Where do you get?
Oh, I'm worried there's another one. I pause on this one, Alia, to show that she is identified in relation to the first claimant in particular then he's good for at least 1.5 million. He will be able to pay that back. There's no risk. You won't get your money back. In the last few lines, she's also saying the second claim has very substantial wealth. That is supplemented behind tab 80. Tab 8 is just a stepping stone to the next handline, because we get the council's note on ABK lending, line tab 80, where at the second page, or page 4238, Mr. Richard Hill of the Shivji of Council say this at paragraph 6. It should be particularly noted the second claimant is extremely wealthy. It would be profoundly unfair if she was deprived of her judgment on account of alleged inability to repay, circumstances where her net wealth is many multiples of the judgment sum. The material deduced by the defendants on the application is not beginning to justify that. And Ms. Hamdan comes with some more evidence over the page, through the divider page at 81, where she makes a further witness statement on behalf of all three claimants. Where at page 4240, which is where we're coming to 72 million, 4240, she says this at 1.2a. I was wondering if I need to read A. Perhaps I'll just go straight to C. C. Notwithstanding the matters set out above, including the foreclosures and personal guarantees. So, notwithstanding all these matters you've raised about problems of foreclosures with ABK and so forth, and guarantees they might be enforcing, notwithstanding all of that, so this goes to the net point, including the foreclosures and personal guarantees. One, the first claimant is a businessman with substantial assets. His net asset position is substantially above the amount of $1.2 million, which he was due under the order of Justice Chadwick, Deputy Chief Justice Chadwick, if that sum ever had to be repaid. Two, the second claimant has very substantial assets, including unencumbered personal and real property assets, and net assets, are in excess of $70 million. So a net position substantially above the amount of $8.5 million, which is due under the order if it has to be repaid. While the third claimant does not have an asset position of the size of the first and second, as the spouse of the first claimant, she still has available more than sufficient assets, covering the amount of $645,000, which is due under the order if it ever has to be repaid. So they're saying they can pay that money back from their assets, and the assets are are very substantial. And even the first defendant in his own right is said to be easily able to repay $1.2 million. And of course, this is all after they have funded the trial. So it's not as though, so we're talking, by implication, we would be looking at funding the fees in the position before this, and even they've still got this money even after the trial has happened. But there's one other piece of evidence that may touch on this, where Mr. Noor, who's the office manager of the first claimant, he did give evidence? He did. Yes, he gave evidence at the liability trial. Is quoted in a subsequent application that was the spat which the claimant had with Vannon, the litigation funders, it resulted in a number of rulings of this court. But one of the rulings appears from puts 9 away, takes up 110 at 102. This is an order of Sir Richard Field in relation to the Vannon dispute that Mr. Khorafi had with his funders, and I just wanted to show you what he says about that. He refers in 22 on page 5038 to Mr. Khorafi's application for an order varying a previous order. This is all the stats about the litigation funders had said they're entitled to recover to get back the money paid by the defendants in the first action, and they should be paid into an account of the solicitors who were KBH at that point. And the monies were not paid into that account, and there was a spat about that. And in that context, the various applications made. And he says at 23 that this application was supported by a witness statement made by Mr. Mohamed, who is employed by the first applicant, our first claimant, as an office manager and advisor. The Khorafis argued they were making an interim application to which RDC applied, was an interest of justice that the order structure be granted, even assuming that as the litigation funding agreement, RLFA was valid and binding. The assumption the Khorafis disputed in the later part of their argument, it was submitted that it was in the interest of justice the application be granted because Mr. Khorafi had incurred unpaid debts totaling 2.4 million in pursuing the claims. The main action was unable to fund resisting the Sarasin project, having appealed out to the cash flow available to it, particularly the Khorafis and so forth. So I've lost my reference to
So Mr. Noor was saying that Mr. Khorafi had no money.
he is at that point. There's another passage I want to find by which I wonder if your ladyship would
Paragraph 65 you're looking at.
sorry, which
Is that the conclusions you're looking for?
I wasn't looking for conclusions. I've lost the.
I suspect it's around paragraph 75 where there's something about assets that I haven't looked at.
Well, I wonder if it would be convenient to have a break.
Yes,
now.
very good.
I'll save time after the break by finding the passage.
All right.
All right.
My apologies for losing the reference to that point. We've been looking at number 10, tab 102, and we have been looking at page 5038, which was some submissions made at Mr. Khorafi's behalf that he had unpaid debts and was unable to fund an appeal in the main action. If we go to the judge's, some observations made by the judge at 5042, heading through the page above 43 Defendants case resisting the Khorafi's applications. The passage I wanted to direct you to is over the page in 5043, 3 lines in, where it says, moreover, there was no evidence that the Khorafis lacked the resources to pay the debts they faced. On the contrary, Mr. Noor had claimed in his witness statements that Mr. Khorafi had the means to pay the debts, even if the Khorafis lost the liability appeal. The only subsequent developments for the orders of Justice Charles given the Khorafis permission to appeal, etc. So Mr. Noor, it seems, had made plain in the witness statement that Mr. Khorafi had the means to pay the debts, even if he lost his liability appeal. Now, so far as the evidence of assets is concerned, there was all of that evidence that Mr. Khorafi would have been able to fund any extra costs of bringing the deceit claim. He, on the application below, chose not to put in evidence of his asset position. He was not forthcoming, notwithstanding that the evidential burden was on him. He was not forthcoming about his asset position despite multiple requests to do so, nor was he forthcoming with any estimate of how much the additional cost burden would have been, which would also have been incumbent on him to explain. But he wasn't forthcoming. That's despite the fact that we asked a number of specific requests about his asset position in the RFI that we had looked at previously in bundle 1
behind tab 7, there are a series of requests which are directed not only at the abuse claim, but also would have been germane to the actual claim, because of course the whole causation of the actual claim depends on Mr. Or at least may depend on Mr. Khorafi's ability to fund from other means his other debts. And we asked a whole series of questions. But if we look for this purpose, perhaps at the request itself, because all of these requests are just stonewalled. The request is behind tab 6. And at page 60, tab 6, page 68, there's a series of requests made. 20 to 24, all about Mr. Khorafi's asset position.
Tab 6,
Tab 6 at page 68. This is the RFI. These are actually the questions. Their answers are behind tab 7, but one sees the questions being put at 20 to 24. 21, what was the first claimant's approximate net worth as at the date? Given by way of an overview, what sort of assets, investments made up his net worth, and so forth. There were further questions put on page 73, which at the foot of page 73 you get questions from 47 through to 49. Is it the first case that none of the person access to funds or liquid assets if it can be interest payments or the UK investments? The second third there's approximate net worth of the interest payments if ever fell due. What sort of assets and investments made up the net worth identified above, and so on. And then finally on 74, at the foot of 74 you get request 55. For the reply to verbal efforts to illiquid resources, liquid resources, say what they were effectively. And then that was on 56, probably particularly personal financial affairs as they stood referred to here. And then various questions at 57, actually through to 16, there were a lot of requests about.
So he didn't give enough information?
He did stonewalled all of these.
Right. So he stonewalled everything. Is he making a fuss about the judge's non-finding that he did not have?
Yeah.
No, he's not. So why are we going on into this in such great detail?
We don't have to.
Yes, thank you.
He did not say that he could not fund. And there's no, there's no cross appeal. One doesn't obviously appeal against particular findings in a judgment. One appeals against orders, but it'd be very hard in our submission to go behind that and to actually say that the judge. And in fact, it seems that the claimants are backing off the funding argument because in the skeleton below they rather did so. And that would take us to the last ground of appeal. Oh, sorry, just before we do, I need to correct something I said earlier. You Lordship asked me about how it was that by effectively that we got a quantum trial in the 2009 proceedings when there hadn't been a split trial to begin with. And I said that I believe there had been an agreement between counsel at the beginning of the trial. It wasn't quite that way, having looked into the archaeology of it. What seems to have happened is that the quantum game came about by default because shortly before trial, and we can provide the references to this in the bundles, shortly before trial, the claimant served an expert report from Griffin on quantum. That was, I think, a few, matter of 4 days before trial. And in the openings, my clients obviously grumbled about it being late, essentially tried to reconcile the position. And by the closings, in my clients' closings, we said, we've done our best to reconcile, we can't agree, I'm afraid. And so the matter was left hanging, so effectively, quantum went off by default, rather than, I think I said it was an agreement. It seems to have been, it happened rather by default than by agreement, just to be accurate. Which brings me to the ground 13, the last ground I think I haven't dealt with, which is the judge at 36 of his judgment said that there was some force in, this quote here, if I can actually take you to 36, just about 6 lines up from paragraph 36 of the judgment.
so on the right-hand side. He said, in this regard, there's some force in the claimant's submission to the bank's reaction to the new claim somewhat belies any concerns to manifest harassment. It was only after seeking substantial extensions of time to serve a defence that the application was taken out. So, effectively, Judge saying, well, the bank's reaction belied any concern that they were being harassed, and he treated it as some indication that the bank didn't consider itself to be harassed or abused in this case, which, for the avoidance of doubt, the bank most certainly does. This is again a factor which the judge failed to analyse properly. In the Johnson and Goldwood leading authority, there was a delay of some 4.5 years before the defendant applied to strike out, with some participation in the case in between. So you can see why the court in that case was prepared to draw an inference that had there been harassment, it would have been manifest before 4.5 years. That was an extreme case, and I think the claimant's own submissions on the permission here, they described it as an extreme case. It's behind tab 5 and page 77, paragraph 39. Sorry, 51. Sorry, I've written another wrong reference. I do apologise. Yes, 50. Yes. Sorry, great. The delay in Johnson, 51 on page 82, the delay in Johnson was extreme. And of course it was, 4.5 years. We are light years from that case here. Here we were served eventually with a 50-page particulars of claims, and Clifford Chance made it clear from the outset that the claimant, because the defendants were considering the abusive character of the proceedings. One can see that from Honourable 1 below tab 21, the correspondence. For this purpose, page 223. And this is Clifford Chance writing to Hamdan Shamsi on the 26th of February 2017. And they say at page 223, that's D, reliance is placed on findings of Deputy Justice Chadwick in the earlier proceedings to respective clients, and careful consideration is to be given to the preclusive effect of any of the several local judgments and the question of whether the innocent proceedings comprise an abuse of the process of the DIFC court. So careful consideration has to be given to that. And we then serve a request for further information expressly without prejudice to any entitlement to apply to strike out. That's back in tab 6 of the same bundle, at page 64, tab 6. The first paragraph of the request for further information says it's made without prejudice to any applications the second defendant may make for immediate judgment of the strike out part of the claim. And back in the correspondence tab 21, that's 231 in this case. There's a further letter from Clifford Chance, the 10th of May, that's 231, tab 21. The last paragraph, of which in the first page says, nevertheless, our client's immediate focus is inevitably on the abusive character of the instant proceedings. Our client's made a number of requests seeking clarification as to whether it's your client's case, the claim is now brought, could have been brought in the 2009 proceedings. Appears to be your client's case, the claim could not have been brought, but their reasoning is thoroughly opaque. So a clear and immediate focus on the potentially abusive character of the proceedings by the bank and its lawyers. And of course, a number of the requests were directed at just that, to ask them why these claims could not have been brought in the earlier proceedings. Now, that approach is entirely consistent with the defendant that thinks it's been abused, but it's been served being abused. It's been served with a 50-page pleading. There's 8 years of history. It has new solicitors and counsel. It's taking the responsible step of taking some time to look at it, ask appropriate questions, so that it's understood the case properly before it makes the application, and the application is then issued on the 1st of June.
So that was what period of time?
Service of the, on us, in the
What, January?
chronology was, I think, February, maybe. It was January. I will be given the date.
On the chronology?
The chronology is at 9 tab 3.
Yes. Claim form issued 6th April 2016?
Yes, it wasn't served for quite a lot later, on my clients. It was...
Particulars of claim filed 9th January, is that it?
Yeah, 9th of January 2017. So, 9th of January 2017, and so we were considering and focusing from the outset on the potentially abusive nature. We were asking appropriate questions and taking care to consider in case we missed something. And the court doesn't really want to encourage trigger-happy parties who bring poorly considered applications. We made it very clear we considered this as potentially abusive. And the judge's approach in this case is, on the contrary, is likely to encourage parties to make...
I'm sorry, but you do take a long time to answer my question.
I do apologise.
Yes, so you were served in January, and you filed the application in?
Oh, I'm sorry, I mentioned that. 1st of June. I thought I had mentioned that.
Sorry, I didn't hear you.
I apologise.
Yeah, well, I apologise for not hearing you, but...
Wasn't clear.
Okay, so not more than less than 6 months.
Less than 6 months. But my point, I'm sure you reached, is that the conduct of the bank in this case was entirely consistent with a defendant that felt itself to be unfairly harassed and was investigating the proceedings, and then brought the application in a timely manner and shouldn't have been relied on by the judge. Its reaction to the proceedings should have been relied on by the judge as indicative of no abuse. I wasn't going to say any more unless you have questions to bring that on.
Thank you very much. Yes.
My lord and my lady, just to give you the general scheme of my submissions, I'll make some general introductory remarks, the main point being that the approach we say that the court should adopt in considering this appeal. I'll make some submissions about that, namely that it should, as a matter of law, be very slow to overturn the judge's emphatic decision that these proceedings do not come even close to being an abusive process. I will highlight some of the passages in the authorities on abusive process which are relevant to that approach, and which confirm that the approach taken by the judge, whose statement of the legal principles of paragraphs 16 to 23 of his judgment has not been challenged by the bank, was unimpeachable. Not only is his decision not wrong, it's quite obviously correct in our submission. I'll also take a little bit of time just to remind the court, or explain to the court in the first instance, in fact, of the context in which the claim arises, and explain why, although there's obviously some connection between the 2009 and the 2016 proceedings, that they're actually quite different proceedings, and it's therefore not only not surprising that the claimant didn't seek to bring, or did not realise that he had the ability to bring this claim within those original proceedings. But also, of course, it goes to the question that you will have to consider in relation to the hypothetical CMC, if that becomes a relevant issue. But the short point is that the original proceedings, and I think my lady identified this at the outset of my learned friend submissions, the original proceedings concerned mis-selling to the claimants of various financial products, and they were concerned predominantly, almost exclusively, with matters which occurred pre-contractually, and all of the causes of action were causes of action which arose pre-contractually, whether the regulatory claim, the negligence action, and the fraud claim that was advanced, and focused exclusively on that period, although there were some issues, particularly in relation to whether or not Mr. Khorafi had an awareness and the question of his credibility as to his sophistication and whether he knew about the riskiness of the investments, which meant that what happened in August 2007 was relevant to that issue. But it wasn't at all relevant in terms of the representation question or the pre-contractual issues.
But the 40 million that was produced in August 2007, that was part of your claim.
That was part of the claim. I'll actually come to explain how that's broken down, because there's actually a passage in the Deputy Chief Justice's decision in the liability proceedings, which actually explains how that's broken down. But that's right, we were claiming in relation to
yes,
some of those.
Yes, because there's the original investment you make, then
yes.
you say you're conned into making another investment,
yes.
so to
yes.
speak.
Yes.
And what you want is damages for that, get it all back.
That's right, but the focus in relation to each of those, and obviously various notes were purchased across the period.
Yes.
The focus was on what we were told in order to induce us
in the first place.
To buy those instruments.
Understood.
And of course, these proceedings arise from a dishonest statement made by Mr. Walia in August 2007 in relation to post-contractual matters, those being the performance of the investments themselves. And we say that's a very different matter, and the focus was entirely different between the two proceedings. Once I've addressed my lords and my lady on those matters, I'll then address the grounds of appeal and pick up on the points made by my learned friend in submission today. I propose to take them, with your permission, in a slightly different order, and I'll explain why. I propose to address ground 6 first, and that is the issue of whether the claimants could have advanced a non-demurrable plea of fraud against the bank on the basis that in making the dishonest statement in August 2007, Mr. Walia was acting within the scope of his authority from the bank. I'll address that ground first because, in my submission, if the bank cannot persuade you that the judge was wrong to find that the claims could, let alone should, have been pleaded prior to the May 2013 trial, then most of the other grounds of appeal fall away because we don't get into Aldi, we don't get into the hypothetical CMC, because, and this was actually the primary basis of his judgment. He only considered the CMC, as I'll show you from the judgment, in case he was wrong about our inability to properly to plead the authority question prior to the May 2013 trial and Mr. Walia's evidence. So, in a sense, and if my lords and my lady are with me on that approach, and dismissing grounds 6, and I think grounds 3 and 9 would also come into account, would in effect be a shortcut to dismissing the appeal. And the converse doesn't hold true. So even were grounds 6, 3 and 9 to find favour with the court, in order to succeed, the bank would also have to persuade the court that at least grounds 7 and 8, that's funding and the hypothetical CMC, were good grounds of appeal. As a preliminary point, I'd also like to make clear that we stand by the submissions that we made in our skeleton argument for the first instance hearing, which the court will find at bundle 11, tab 115.
Is there anything significant in that?
No, there's not, but if there are any matters, I mean,
Right.
inevitably I'm not necessarily going to be able to address all matters.
No, you're just making sure we're aware of that.
Exactly. I think it would be helpful to be aware of that.
Yes.
We also rely on the submissions we made in our skeleton in relation to the permission to appeal hearing. That essentially stands as our submissions in response to the appeal. But I would be grateful if the court would have regard to both of those documents, because inevitably I won't be able to cover every single patch of grass in these submissions. So first of all, some introductory remarks about the approach that, in our submission, the court should take, and the reasons for respecting the decision of the judge below. The bank must persuade this court that the judge's decision, so his broad merits-based assessment, was wrong, and will only succeed if it shows that the judge has taken into account immaterial factors, has omitted to take into account material factors, or has erred in principle or come to a conclusion that was impermissible or not open to him. And that approach is supported by various dicta in the authorities. My learned friend took you to paragraph 16 of Aldi. I won't take you to that again. And said that if a judge has analysed a factor wrongly and takes it into account, then he's taking into account a fact that he should not have done. And I don't dispute that as a matter of principle. But perhaps I could just show you a couple of other authorities which further explain the position. If I could ask you first to turn up the Stewart case.
This is the point that I asked Mr. McQuater about, the difference between leaving something out of account or taking into account something wrongly on the
Yes.
one hand and putting undue weight,
Yes.
so to speak, on the factors on the other, because it's a factor balancing exercise.
It is, and they're two different categories in my submission. One is a question where if something was left out of account, that might be challenged as affecting the legal basis of the decision. If it's a question of giving inappropriate weight to something, then that's a different question. That's really, although it's not quite the authority's emphasised, it's not exactly a discretion that's being exercised. There is actually a lot of latitude which is to be given to the judge in balancing these various factors, which brings it very close to being
a margin of appreciation,
yes,
one might say.
Exactly, my lord.
Yes.
And I think if I just show you these authorities, I think that point is made. So tab 14 of the authorities bundle, if you wouldn't mind turning that up, please. That's the Stewart case. And if I could ask you to look at paragraphs 82 and 83 in the judgment of Lord Justice Clark, please. That's at page 232. And what he says there is, although I agree that the...
What are the paragraphs?
I'm sorry, it's paragraphs 82 and 83, please. That's at page 232. And he says, having cited Aldi at paragraph 81, he says, although I agree that the exercise upon which a judge of first instance embarks in a case of this kind is not, strictly speaking, the exercise of discretion, the role of an appellate court is very similar in the two classes of case. This can be seen from Lord Justice Thomas's conclusion that the appellant must persuade the court that the judge was wrong, and will only succeed in doing so if he shows that the judge has, quote, taken into account immaterial factors, omitted to take account of material factors, erred in principle, or come to a conclusion that was impermissible or not open to him, or plainly wrong. The line between the approach of an appellate court reviewing the exercise of discretion and its role reviewing a decision of this kind is very narrow. This is because the decision whether a second action is an abuse of court involves the court balancing a series of different factors before reaching its conclusion. In this case, as Lord Justice Lloyd observes in paragraph 43, Judge Seymour QC said he was not concerned with what conclusion he would come to himself if the matter had come before him at first instance, but with whether Master Fontaine was wrong. He was, of course, correct to say that the question was whether the Master was wrong, because that's the question identified by the relevant CPR rule. I'm not persuaded he was wrong to say that he was not concerned with the decision which he would have reached if it had been the judge at first instance, here the Master, because it seems to me if the approach to the appellate process identified by Lord Justice Thomas and the above passage is correct, there may well be cases in which the appellate court might itself have reached a different conclusion, but cannot properly say that the judge or master was wrong because he or she took into account immaterial factors, etc. So I think, my lord, that really addresses the question that you asked. In my submission, although if the court was to take a view that one of those balancing factors has been approached in an irrational fashion, that might be different. There is this margin of appreciation which is given to the judge's decision. So that's Stuart. If I could ask you to turn forward a couple of tabs, please, to tab 16. And this is the case of Gladman. And if you'd please turn to page 300, that's paragraph 43, I would like to draw your attention to. That's right at the bottom of page 300. So the judge's decision that the bringing of the second claim amounted to an abusive process by the appellant was, although not involving the exercise of discretion, the result of his balancing of relevant factual and other considerations with which an appellate court will be reluctant to interfere. And he cites the Arab insurance case. Generally, this court will only interfere where the judge has taken into account immaterial factors. So he repeats the same point. And just finally, if I could ask you to turn forward, please, to tab 22. This is another Court of Appeal decision in the Wilson case. And if I could ask you to look at paragraph 48.6, please, which is at page 437 of that case. And I think it's Lord Justice Simon, an appeal against the decision to strike out the grounds of abuse described by Lord Sumption in Virgin as the application of a procedural rule against abusive proceedings is a challenge to the judgment of the court below and not an exercise of discretion. Nevertheless, in reviewing the decision, the court will give considerable weight to the views of the judge, and then cites Lord Justice Buxton in the Taylor-Walton case. So the authorities are clear, and in my submission, that means that the bar is really a high one for my learned friend to surmount. It's not enough for this court to decide that it would have come to a different decision on the balancing factors. It must be satisfied that the decision was a wrong decision, exercised to a wrong exercise, akin to the wrong exercise of the judge's discretion. Now, in relation to the judge below...
I mean, it is a little bit different, isn't it? Because discretion is one thing, but I can't remember if it's Aldi or Crete where they said it's a question of whether the judge is right or the judge is wrong. And if the judge is wrong, well, then you reverse it.
Yeah, well, that's
which is different with discretion, because discretion means
yes.
You wouldn't get come to that decision.
Yes.
You let it go.
Well, I wouldn't disagree with that, my lady. I think it's really a question of what the
Well, that's right. Somewhere there's only one right answer.
There's only one right answer, but in coming to that, in relation to the balancing factors, there's quite a wide margin of appreciation given to the judge in considering
what
those
it comes
factors.
to is it's a review
Yes.
function that the Court of Appeal is carrying out rather than anything else, I think.
Yes, my lord. Exactly.
But as I rather indicated to Mr. McQuater, one's experience of these things is the courts tend to find something to peg their decision on, and to call something which one person has said is simply putting undue weight on a factor. They may well label a failure to take something into account.
Yeah, well,
so we're always into an area of factor.
Of course, and I accept that, and that's a very realistic
That's a
assessment.
realistic approach, I'm afraid.
Yes, but it is ultimately
How
a
wrong
broad.
do you think the judge was?
But ultimately, it is a broad merits-based assessment.
Indeed.
That's where that's the starting point.
Due weight must be given to the decision of the first instance.
Absolutely, my lord. Absolutely. And I, just in relation to the approach that one can see, though, from the authorities and the recent cases, if one looks at them, one can see actually that in the majority of cases, you either have a court refusing to disturb a refusal to strike out, or actually in a case such as Aldi, for example, actually in the appeal court saying that the decision should go ahead. And when one looks at the decisions, there are very few of the decisions. I did have a note that Mr. Rosen helpfully prepared for me, which seems to have gone astray. I might come back to that tomorrow when I can find my notes again.
The point being that the court would tend to leave things to run their ordinary course and only strike out in a clear case.
Yes, exactly. But the court, in my submission, actually tends to give the benefit of the doubt to the claimant, as is right, and in my submission, in the interest of justice. Turning to why, in this particular case, the decision of the judge should be accorded particular weight. Of course, he was a judge who had real familiarity with the 2009 proceedings, and he was in a position to form an overall view of the balance of justice, of what would or would not have been possible, and to have a sense of those proceedings generally, to feed into that broad merits-based assessment. So he was, and one can see this from the judgments in the bundle, but he was part of the Court of Appeal in the claimant's successful appeal on jurisdiction. He was also part of the Court of Appeal hearing the defendant's unsuccessful appeal on liability. So this was, as far as I'm aware, the third time that he had been asked to consider the question of twice the 2009 proceedings, and then on the occasion we were before him in March, these proceedings. And of course his judgment is very clear. And in my submission, the fact that he had familiarity with the previous proceedings, and given that the essential thrust of the application being made is that the proceedings are duplicative, they're abusive for that reason, he was in a very strong position to form a view of that. And in fact, it's somewhat incredible that the bank suggests that this very experienced judge, experienced generally and experienced in the litigation which has passed previously between these litigants, made no less than 13 serious errors, of which each of which is said to undermine his judgment and is said to be so wrong that the court should set it aside. In my submission, it's entirely improbable that the judge would have fallen into so many serious errors. Indeed, it's clear that he did not do so, as I will submit to in relation to each of the grounds of appeal. It's also relevant in my submission that the judge appears to have given permission to appeal with some reluctance, and did so on pragmatic grounds, having recognised that any appeal would be approached in a similar manner as a review of discretion. Perhaps I can just make that point good by asking you to have a look at the reasons for granting permission to appeal, which are at Core Bundle tab 9, page 107. And one can see at paragraph 3, he sets out why a judge of the court of first instance should exercise caution granting permission to appeal. And then at paragraph 4, he says it might be thought in the circumstances it would be desirable to refer the application to the Court of Appeal. But I have much in mind the enormous level of cost that has been expended on this prolonged and ill-timed litigation. Thus, having given careful consideration to the merits of the application, the benefit of extensive written and oral argument, I concluded the prospects of success have just surmounted the threshold. Accordingly, I have decided it's right to grant leave to appeal. In my submission, that suggests that he was taking a pragmatic view as to what was likely to be best, given it was inevitable, given the history of these proceedings, that if he refused to give permission, an application would have been made to this court. So none of this, in my submission, is a promising start for the bank. On any view, it has an uphill struggle to persuade this court that an experienced commercial judge who gave his decision on a broad merits-based approach having had significant experience of the 2009 proceedings, was plainly wrong. I'll turn now just to give you, my lords and ladies, some general background factors to the litigation and a little bit more colour on the submissions I made at the outset about why these proceedings are very different and some of the relevant background. This application is, in my submission, yet another unattractive attempt by the bank to stifle genuine claims which the claimant has against it, which arise indirectly this time out of the mis-selling of the bank's products in 2007 and 2008. And I won't ask you to turn it up, but you may recall from pre-reading how Mr. Justice, or DCJ Chadwick, characterised the conduct of the bank and the first defendant being a 60% owned subsidiary of the bank and not an entirely different entity. How he characterised it in 2007, and for my lords and ladies' notice, Bundle 8, tab 75, page 4052, and he found first that the bank was operating in Dubai via the first defendant without a licence, which we say is hardly credible or creditable from a so-called reputable Swiss bank. He also found that the first defendant forged internal documents, and one can see that from the indemnity costs order that DCJ Chadwick made in October 2014, and that, for your lordship's note, is at Bundle 9, tab 78, page 4227.
And is this Mr. Alia, or are there others involved?
It was Mr. Blonde, as we have to call him. Mr. Blonde, who's, I think he's being referred to by his real name, Mr. Nair.
Right, okay.
Yes. So there was an order made previously that Mr. Nair had referred to.
We're not talking about one rotten apple in the barrel.
No, we're not. We're talking about at least Mr. Weiler and Mr. Nair. They both were working for the first defendant, but I've been asked to make that clear. But the point is that that was a 60% subsidiary, and DCJ Chadwick's findings are pretty clear.
Sorry, I got the impression that Mr. Nair was working for the second defendant, or because he was working for the first defendant.
He was working for the first defendant, my lady, yes.
And I'm sorry, but I have to say it's Mr. Nair.
I'm sorry,
Yes,
Mr. Nair.
I wanted to tell well-learned friend, but I held my peace, but it is Nair.
Mr. Nair. Well, maybe I should stick to Mr. Blonde, which is rather easier. But I will try to, if I refer to Mr. Nair, I will try my best to remember how to pronounce his name. So, while the bank seeks to draw a distinction, and my learned friend did so in various points of the submissions he made between itself and the first defendant, and although it's right that different judgments on quantum were made against each, in my submission it is a rather artificial position for him to take, particularly given that they were represented by the same solicitors through the liability stage of the proceedings, even though they had separate counsel who shared the burden of the submissions. Now, the bank continues in the approach that it took in the previous proceedings to take every point, and after a delay, which I'll come back to, of 5 months between being served with the particulars of claim, seeks to strike them out as an abuse. And already, if this appeal is rejected, as it should be, the bank is already preparing its next line of defence, which is to avoid dealing with the substantive merits of my client's claim by launching a forum convenience application, for which directions have already been given if this appeal is unsuccessful. And it will try to persuade this court, by that application, that it shouldn't hear these proceedings on jurisdictional grounds, on the basis that they should be heard, if anywhere, in Switzerland. And no doubt if it loses that application, it will appeal as it did at every turn in the 2009 proceedings. So what we see is a pattern of conduct now repeating itself in these proceedings. I submitted, and this is dealing with ground 13, with the grounds of appeal, which my learned friend finished with, so I might as well deal with it now, or at least in summary terms.
The only difference between the application of that kind that failed before and any application they would take now is that the first defendants were liquidation. Is that right?
That's right.
That's the only distinction that could be drawn between the decision that's already been taken.
Well, they're also different claims, so there might be some considerations which arise in relation to that. But yes, I mean,
it's on the same basis as an exclusive jurisdiction clause, which this court was prepared to override last time round.
Yes, that's right. Although the first defendant is also a party to these proceedings, and although given that it's in liquidation, we haven't yet served, but there is an application to continue the stay on service.
That's the only relevant ground of distinction that this court would have to grapple with.
I think that's fair, my lord. Yes.
Yeah.
But just dealing with the delay in launching this application, in a nutshell, faced with these proceedings that it was served within early January 2017, so now nearly 2 years ago, the bank first of all wrote a letter, and that was the 22nd of February letter, said it was giving careful consideration to whether or not it should make an application to strike out. But that in itself suggests that it wasn't something that was so obvious to them that they just ran off to court to start an application. But secondly,
Mr. Thompson, if I may say so, but the same as I said to Mr. Quater, and indeed you yourself said earlier, this isn't the key point, is it?
No, I appreciate that, my lord. It's obviously a ground of appeal.
The sooner you get to grounds 6, 3 and 9, the better. If I may encourage you in that respect.
Of course,
I don't want to cut you short on anything.
Well, I'm very happy to be cut short and to save my voice, but it was dealt with, and it was dealt with at some length.
It was indeed.
And I thought it might be convenient just to deal with it now. It hasn't been withdrawn as a ground of appeal. And so I must deal with it or say something, but I entirely take the indication and respectfully agree. But very briefly, my lord has the points, I think, but they obtained 2 extensions of time to serve their defence, one from us at the beginning of March and one from the court in the middle of March, both on the basis that they needed time to respond to a complex particulars of claim. So the applications were made on the basis that they needed time to consider the particulars of claim, and in order so that they could prepare their defence. But of course, when the 1st of June came around, the deadline for the service of their defence, instead of issuing their application, instead of serving their defence, they issued their application to knock out our claims on a technical basis. And in between times, they served 2 requests for further information. And my learned friend complains about the fact that we, as he says, stonewalled some of the requests. They're entirely improper requests. Passing up 19 is a process for obtaining further information in order to understand the other party's case, in order that, in this case, you complete your defence. It's not a vehicle for making speculative fishing expeditions in order to try to...
If they're dabbling with these things, that doesn't affect the merits of this application.
It doesn't, apart from this, and I have to address the point because it's one of the grounds of appeal, but it is said that...
It's not an important ground of appeal.
It's not an important ground of appeal, and I'm happy not to say anything further, but it was said that it was wrongly taken into account at all, and that the comment that was made was entirely unfair. And the short point, and I'll make this point and leave it at that, is that a party who feels that it is being unjustly harassed does not make speculative fishing expeditions for information. It doesn't obtain extensions of time to serve its defence. It gets on, it makes its application. Abuse is something that the party should see as obvious in my submission, if it is abusive, if it is harassment. And the fact that they waited 5 months, the fact that they had to make speculative fishing expeditions for evidence to try to bolster the application that they intended to make, in my submission, is something certainly it can't be said that the judge was wrong to take into account.
But coming to the nub of the issue, you won't be contending, I imagine, that if this claim could and should reasonably have been brought in the prior proceedings, that it doesn't constitute harassment and abuse of process.
If it could and it should have done,
Could and should reasonably.
If both of those are fulfilled, then that's
enough.
That's enough.
Yeah.
Yes. So, subject the unjust harassment is also a factor on the authority. So
Well,
if one goes back to Johnson
but
and
the
Galway,
reality is that the harassment is there in that very fact, if it could and should reasonably be reproduced in the first case.
with
all
respect-
other things being equal.
All
But
things
in an
being equal.
enormous case.
In a sense, yes, but it's a matter of fact in every single case. We've got Lady Justice Sarasin in Crichton making the point about generalised prejudice. So it's not enough to say, oh well, I'm now going to be facing proceedings, whereas I didn't have to be. You have to show something more than that. So my submission is that could and should on their own are not enough. You have to show some harassment, and it has to be more than generalised harassment. And I accept that the party may well be able to demonstrate harassment, but it's not a foregone conclusion. It doesn't necessarily follow, even if the could and the should boxes are ticked.
Sorry, if they could and they should, it's still not harassment.
There has to be something other than generalised harassment.
But wasn't
Yes.
that in relation to a different defendant?
That was in relation to a different defendant. So as I said, it turns on the facts of the case. But it might be, for example, if you could and you should, but as we say would have happened in this case, the same thing would have happened. So you would have had a separate set of proceedings anyway, which so therefore you have no or little duplication of the proceedings. Then there isn't any harassment, even if it's the same party. The point is obviously much easier to make where you have a party who wasn't part of the first set of proceedings.
If it would have made no difference, that's really what it
Yes.
amounts to. Or as near as
Exactly.
made no difference.
Yes,
Yes.
as near as that. So there has to be something which is significant as a matter of harassment, but just one further background point. This is a point of background rather than addressing ground 13. Just in terms of the background situation, I think one can pick this up if I could ask you to turn to Mr. Bowden's witness statement, which is in Bundle 1, tab 18, on page 6. This is just about what's happened in relation to the liquidation of the first defendant.
Sorry, the reference again.
I'll give you the reference rather than, again, it's tab 1, Bundle 1, tab 18,
Thank you.
page 6.
Yeah.
And Mr. Bowden there, bringing the court up to date with what's happened in relation to the liquidation. And one can see paragraphs 15 to 18. So the 2009 proceedings resulted in any incomplete justice because the defendant had to pay the first defendant had to pay 35 million, which is ordered to pay on the quantum judgment. And he makes the point about them being a joint venture, 60% owned by the bank. And then on the 2nd of May, it was ordered to be wound up. The chances of recovery at all in the liquidation, let alone any substantial recovery, are uncertain. And he goes on to make the point in paragraph 16 that the first defendant was left with assets of approximately $600,000 being cash in the bank. Then paragraph 17 says, I understand matters at the time of the liquidation of the company, it was not operating, a very substantial client base and substantial operating revenues formerly enjoyed by the company had devolved to new entities, starting by the original shareholders of the company. These entities were started after the 2013 hearing, but before judgment had been delivered. In the case of the bank, it incorporated Safra Sarasin Asset Management. The first defendant hived off its business to this company, and the new company, opened by Alpen Corporation, then surrendered the licence to operate in the IFC.
I thought you just told us they didn't have a licence.
The new entity has a licence. D1 had a licence. The bank didn't have a licence, and that was what was at issue in the, or one of the issues in the liability proceedings.
Okay. Sorry.
And what was found was that they should have had a licence because they were operating. So what they've done, essentially, what it looks like from Mr. Bowden's evidence, is that D1 has been run down, the assets are being transferred. And in my submission, that is a relevant background factor for
Sorry, to justify you bringing this action? I don't see how it's relevant. I mean, it's unfortunate, maybe, to say the least, that the bank is not, the first defendant is now in liquidation. But that doesn't mean of itself that you can bring the second action.
No, I'm not suggesting it's forensically relevant to the analysis of the Henderson test, but it is a background factor. And what the court is doing is assessing broadly the merits of the claims and the merits of the position. And in circumstances where the bank was the majority shareholder in the first defendant,
I'm sorry, but I really don't see the relevance of this fact, whether it's background or it's anything else.
Well, in my submission, it goes to the kind of conduct that I need to say no more about it. It's not something that I'm pressing.
That conduct is a generalised business conduct and not related specifically to any statement, any reliance on any statement, any losses suffered by...
No, I agree.
No, I take it the second defendant has paid, has it?
The second defendant has paid part. There is still an outstanding, this is no criticism, but there's an outstanding question about the interest.
Interest and costs, we were told.
Exactly, but it's paid what it's been
paid.
ordered. Yes, I make no criticism of that. It's paid what it's been ordered to. After a fight, I'm reminded, which again goes to the general conduct.
Yes.
I was just going to make some brief submissions as to why the 2009 and 2016 proceedings are different. I am happy to do that first thing tomorrow, and I might be able to rationalise my notes overnight as well, given the clear indication that my Lord and Lady want to be addressed on
whichever you find
particular grounds.
The most efficient and convenient.
I think it's likely to be more efficient if I rationalise my notes a little bit, if that's convenient.
From your perspective, we're in no difficulty about finishing tomorrow with good time for a reply and so on.
Yes. Well, certainly I would imagine that I'll go on slightly after lunch, but then give my learned friend plenty of time to reply.
Yes, but if you would rather...
I think it might help me just to rationalise my notes and focus, given my lords and ladies indications to what would be most helpful.
Very good. All right. 10 o'clock tomorrow morning then.
Great.
Thank you very much.
All rise.